Hello, everybody. I trust you can hear me. Let me move the microphone a little bit closer to me. Apologize for any clicking or clacking. This is not what I want to do. I don't really care about this particular case. I'm not a Turtle Boy fan. I have no real interest in the underlying case, the Karen Read case. So I don't really have an interest in this. But I've had a lot of people ask me about it, so I figure I'd go over it. And I simp for Kate so hard. Wow, that's pretty cool, bro. I guess we know your bias. I believe I have stated specifically on the record that Kate is a liar, and that of the Massachusetts group, Turtle Boy is probably the one who is most honest. They're all annoying as fuck, except for Kate, because I like Kate. She seems like she would be fun in a dirty kind of way, and she has big old titties, which Turtle Boy doesn't have. I guess that makes me a simp for Kate. Somebody did a thing. I do have an email. I have several emails. You could find one on my YouTube page, and you could also find one on my State Bar page. Those are the two emails that I give out to the public. But them titties, though. You would jumble them titties. Do not lie, sir and or madam. You would jumble them titties. All right, so we're going to start off with the complaint against Aiden. I don't know why we're going to start off with it, but I figure it would be probably the best way to go. Simping for her. Yes, you figured me out. Jeez, what a retard. I swear to God. That's one thing I really hate about the Massachusetts people is that people seem to really pick sides in the Massachusetts thing. Like, I don't understand the ongoing. I don't know why between Kate and Turtle Boy, neither of them is fucking mature enough to just let it go. I can't understand it. Like, she does terrible things to keep it going. She's not a good person. I mean, she's not a good person. He does terrible things to keep it going, and he's not a good person. But at least he's not a liar. I mean, that's the one thing. He's not a liar, and she has nice tits. Why wouldn't you have an interest in this? You cover mentally ill people harassing police. This is right up your alley. Maybe not taking sides with drama and just, well, like, who the fuck are you? Like, you literally called me biased a minute ago. You half-wit. You literally just called me biased and then just don't take sides. Like, where have I taken sides in any of my analysis? Jesus Christ. It's people like you, Aaron, who really make me not want to cover this. And you're one of the people who was begging me to cover it. So, like, Jesus fucking Christ. You wonder why I don't want to cover this shit. It's because terrible fucking people come out with their terrible fucking biases, and they try to if I say that Kate is in the right, then I'm simping for Kate. If I say Turtle Boy's in the right, then I'm a Turtle Boy dick rider or whatever they call me. Like, a half-wit is less than a midwit, sir. A half-wit is less than a midwit. Aiden is rather a substantial liar. Well, I haven't caught him in a lie yet, and I don't fucking defer to your opinion on who is or isn't a liar. Billy Badass. Jesus fucking Christ. Everybody, simp for your team now, boys. Simp for your team. Dixie Norman, simp for your team. Let's go. Get it out. Just air it out. Just get it out. Simp for your fucking teams. Simp for your teams. Simp for your teams, everybody. You know, Every fucking time I have looked at one of Turtle Boy's posts is horribly produced, horribly written, horribly sourced posts on his website that is just packed full of shitty ads. Every time I've looked for it, he has brought receipts. Every time. Every fucking time. I don't like the guy. I'm not trying to simp for him, but he's brought receipts. He's brought receipts. It's common knowledge. Like, we're just going to accept stuff on common knowledge. Like, that might be the way you work, but that's not the way I work. I don't accept shit on common knowledge. Fucking hell. Yes, lack of pants. Finally, go Team Merb. I don't have a team. Aiden is, well, I mean, like, just because I haven't caught him in a lie doesn't mean he's as honest as they come. Let's not get carried away there. Aiden simp for the Dolphins. Well, they had the perfect season until they fucked it up. Aiden isn't a liar. He just doesn't tell the truth. Wow. That's a good take. Spicy. I think the situation can be summed up as, did TB violate the statute? Probably. Is it a BS statute? Probably. Is there a good 1A discussion to be had? For sure. Do I care about Reed? No. To answer those points, did he violate a statute? Probably. Is it a BS statute? Probably not. Is there a good 1A discussion to be had? Probably not. Do I care about Reed? Absolutely not. Okay. Are those receipts real? As real as your mom. Hello, how have you been? He's not in a position right now because of his lies. He's in a position right now because he was intimidating witnesses. You fucking buffoon. Jesus Christ. I'm a chicken simp. Hell yeah, brother. Chickens are the best. And a fish simp. That's even more true. My wife is technically the chicken simp. I'm the fish simp. Team Merb is not. I'm not. Yeah, team of one. That's me. It's great to catch a lie. Well, I hope I enjoy, or I hope I give you some enjoyment. Common sense. Yeah, there's lots of that on YouTube. No, there's not. Hell yeah, brother. Poon. Team Poon. Hell yeah. Finally. And can we get a team Big Tits up in here? I could do a fraud or wrangler. Put a one in chat if you're on Team Big Titties. But that doesn't make Turtle Boy an honest person at all. No, and you calling him dishonest doesn't make him dishonest. You fucking idiot. I said I haven't caught him in a lie. Of the Massachusetts crew, he's the only one I haven't caught in a lie, which makes him, in my opinion, from what I have seen, the most honest of the three of them. That's it. That's fucking it. That's it. Like I have literally, straight up cut Kate in big lies, big fucking lies. She falsified a pleading and sent it to YouTube as to show that she'd filed the lawsuit against Turtle Boy, and she admitted to it. Like, she's a confirmed liar. Confirmed. Steak simp. Steak is delicious. Steak is probably my preferred meat. I don't understand people who can't see both sides. People are not black and white. Both people can be right. Both people can be wrong. That's true. Yes, Dixie. Team bolt-ons? Absolutely no. I would rather have tiny mosquito bite titties that are real than bolt-ons. I can always satisfy. Well, apparently you haven't talked to many of the women in my life. Number one. All right, that was a one for big titties. Hell yeah, brother. If you have a caught him in a lie, you're not paying attention. Hey, newsflash, I don't fucking pay attention to him. I don't watch his channel. I have rarely gone to his website, which, again, is shit. So, yeah. Congratulations, Dixie Normus. You figured me out. I don't pay him attention. You do. Which one of us is the Turtle Boy simp? You who watches all of his shit, or me who doesn't? Fucking idiot. Patty Cake's another auditor that lies. Why are you bringing up Patty Cakes? I don't care about him. I haven't covered him in forever. He's a little piece of shit. I have no problem with the statute, but I've heard some fair arguments that it's broad. The judge's order was compelling, though. Fair arguments that it's broad? Well, I don't think so. I don't think so. And I also don't think that you're really looking at it in a Sixth Amendment sense either. Turtle did claim that he didn't know Karen Reed, but recent leaks of text messages between him and Karen leads me to believe he lied. Well, it leads you to believe he lied. Well, what's his definition of no? What's his definition of no? He sent me texts. He knows of me. Does he know me? I've done an interview with him. I guess he knows me. Did he do an interview with her? Exactly, Jeff. He's not worth paying attention to. You prefer steak. And this whole time I thought you preferred cock. Well, tube steak is a steak. Didn't Aiden falsify CPS records? No, he didn't. No, not the ones on Kate. No, those were fucking real. Those are dead ass real, Billy Badass. You've been drinking the Kool-Aid from a liar. Yeah, they both suck. And you know what? I'll bet you Kate swallows, which makes me like her somewhat. I like Kate because she seems dirty. Okay, I'm not saying I'd trust her, but like I'd have apps with her. I'd go out for a drink with her. I'd go out walking around Boston with her just to watch them big old titties jingle. But yeah, I mean, they both suck. I won't give him the views. Well, good for you. I won't give him the views either. Turtle claimed 3 pages of the judges pleading were missing out of 22 while displaying a 22-page document. He said he had to write the court to get it too. I saw the clip. Someone posted it in my Discord. Here, let me pull up my Discord. Discord. Open Discord in your browser. And you know what? It's stupid gotcha shit like this. Like, do you think he didn't know he had a 22-page document up? Like you are nitpicking the fuck out of him. You can say that I lied because I misspeak. Like, what was it? On Thursday, I said, good morning, happy Wednesday. Oh, John's a liar. He said Wednesday when it was Thursday. It's that stupid shit. Like, you want him to be a liar, so you're looking to find stupid shit. Hold on a second. All right. Can we all see it? I hope we can hear it. Let me know if you can't hear it, I guess. They had, past tense, had 3 missing pages at the end. See, this is what happens when you pay attention, Dixie, and you don't go right in there thinking that someone's a liar and looking to catch him in a lie. Had, past tense. We had to call the court to get them. That implies that he called the court and got them. You dumb shit. You fucking pull your head out of your ass long enough to get some air to your brain. You are a dumb shit. I'm Team Suffering. Get out there with that yams and marshmallow. Out of here with that yams and marshmallow shit. Aiden said he had an interview with one of the officers involved in a toilet. He reported as a fact. When he was accused of wiretapping, he said it was a troll. Okay. Like, I don't fucking know what you're talking about, and I don't care. You're not going to prove to me by dumb shit that you say on here that he's a liar, because as we just shown with this dumb shit, people are fucking wrong and stupid, and they take shit out of context. So, sorry, Nima. I don't care. In the South, we make dressing, not stuffing. Well, okay. I would take Southern dressing over Northern stuffing. John, I don't know who that is. Maybe me. Have you seen any of Johnny 5-0's ridiculous auditing videos? Yeah, I've covered Johnny 5-0 a long time ago, but I found him to be boring. He claimed he wasn't talking to Karen Reed at all, never spoke to her, but he did. Oh, but you said it was texts, you dumb shit. Spoke or texted. Spoke, verbal, texted, not. Oopsie. Hello. No, Merb, stop it. I'm not looking from a 6A perspective. That's true. Hadn't considered it. Well, you should, and I did. John Olson still does videos. I haven't seen any of his in a long time, but I haven't been looking. When I make mistakes, I use a lot of salt. Salt makes my steaks taste good. Nice, Miss Steaks. Nice. I like it. Turtle Riders are upset because her boy may be going to prison for a while. Maybe. I'm hungry. You should have some steaks. Do you have a Discord? Yes, I do. Which I literally have it up on the screen, but apparently, maybe it was old. Aiden said he had an interview with one of the officers involved. Did we do that already? Oh, you're repeating yourself. And again, I don't fucking care. A sucker is born every minute. A swallower is tough to find. Hell yes, brother. He's a pathological liar. No, he's not. No, he's not. Again, I haven't seen him get caught in a lie yet. Wow. Other than randomly seeing her case, he had never heard her name, that kind of knowing. Never heard her name. Did he say that? Other than seeing her case, he'd never heard her name? Well, if he was talking about her, he must have heard her name, huh? I don't care whether or not he's a liar. He just is. I don't care whether or not he's a liar. He just is. See, like, that's fucking, like, at least you're being honest about your bias. At least you're being honest about your bias. Well, I don't fucking know what to do, bro. I don't know what to do. Present. Well, I fucking played it. Like I commented on the high points. No audio, whatever. But at least Dixie Normus, at least you're admitting to your bias. And with that, I'm going to ignore the rest of your posts because you are admittedly biased, and you're unashamedly admittedly biased. Team Popcorn, hell yeah, brother. I hear it just fine. Okay. I think the issue is he never addressed that which was favorable. I don't know what that means, but okay. I've only heard of these two because of random videos I've seen. I heard Kate do her beef with Chilito and Turtle Boy when Kate tried to get a PPO or whatever on him. I see them all as drama. Yes, they are all drama. They stir the shit with each other. They nitpick each other to death. Like they don't steel man either side's arguments. They both straw man the arguments. Getting there, stoicism. So does your mom. Okay, TB is an evil man. Like, define evil. Like, what has he done that's evil besides sending out pictures of him, videos of himself jerking off to women who were so unscrupulous that they sent it on to other people? I mean, you tell me. Dressing, stuffing, both are superior. Where's your cock today? You'd have to buy me dinner to find out. And if you're cute enough, you might really find out. You know what I'm saying? Wink. Thank you for your consideration. I hardly wait till Merv is a judge and calls the lawyers morons. I never plan on being a judge, so that doesn't work out well for you. He says he was missing 3 pages that were in his favor. Well, he thought they were in his favor. What's your point? And I played the video. And he says it didn't. It was missing 3 pages. It was like past tense had, and then he had to call the clerk to get the missing 3 pages. There you go. Done. TB is going nowhere. He'll not serve a day in prison. Well, fucking maybe. Sometimes cases get dismissed. Maybe. But maybe not. I mean, you're guessing at this point. That's pure hopium. Dixie is trying proof by repeated assertion. Yes. He said it on Court TV. I don't watch Court TV. So there you go. I feel like some of y'all are way too involved in this nonsense. Yes, they are. See, that's the problem with a lot of this shit. It's like a daytime soap opera that people can insert themselves into. And that's a problem. Is this Hezekiah? No idea who Hezekiah is. He said the missing pages were the most favorable to him. Yes. Thank you for repeating that. I'll watch and reply to hear your take on this. Okay. He's an award-winning journalist. So he says repeatedly. TB doesn't speak on Kate ever. That's a fucking lie. You are a fucking liar. You are a dirty fucking liar. Hell yes, he does. All the fucking time. Hey, everybody. Haha. Oh my God. What Nima said. Being a judge seems like a horrible job. Dealing with idiots day in and day out with no breaks. Okay. All right. I think we're fucking caught up. All right. So we're going to start off with a complaint. So the morning of January 29th, this is about the Reed thing. If you're here, you probably know about it. The lead investigator is Trooper Michael Proctor. The lead investigator could possibly, how's it going, Master Sergeant? How's your gay gamer chair? The investigator is possibly a witness. Investigators can be called on to testify. He is possibly a witness. He testified before the grand jury. There you go. And continues to conduct investigative work on this case. Michael Proctor is married to Elizabeth Proctor. Elizabeth is not a witness to this investigation, but a family member mentioned in Massachusetts General Law 268.13b. All right, well, let's go there. 268.13b is used in the section. The following word shall have the following meanings unless the context clearly requires otherwise. Harass, to engage. This is important. Well, I guess investigator too is important, but he's an investigator. There you go. Harass is to engage in an act directed at a specific person or group of persons that seriously alarms or annoys such person or group of persons and would cause a reasonable person or group of persons to suffer substantial emotional distress, including but not limited to an act conducted by mail or by use of electronic or telephonic or telecommunication device or electronic communication device, including but not limited to a device that transfers signs, signals, writing, sounds, data, or intelligence of any nature transmitted in whole or in part by a wire, radio, electromagnetic, photoelectronic, or photo-optical system, including but not limited to electronic mail, internet communications, instant messages, and facsimile communications. So the important thing, whoever willfully, so that's an element, willfully, either directly or indirectly threatens, attempts, or causes physical, emotional, or economic injury or property damages to, that's one possibility. I don't think that applies. I don't think he threatened anybody. Well, I mean, you could argue that some of those were threats, but it would have to be a true threat. 2, conveys a gift, offer, or promise of anything of value to, so you try to bribe them. Or 3, misleads, intimidates, or harasses another person. I think that's the operative thing that we're going to be looking at. A witness or potential witness. The investigator is a witness or potential witness, a person who is aware of information, records, documents, or objects that relate to a violation of criminal law or a violation of conditions of probation, parole, bail, or court order. Judge, juror, grand juror, attorney, victim, witness, advocate, police officer, correction officer, federal agent, investigator. So he's a police officer and an investigator. Clerk, court officer, court reporter, court interpreter, probation officer, parole officer. A D, person who is or was attending, or a person who has made known an intention to attend a proceeding described in the section. Or E, a family member of a person described in the section. And then with the intent or reckless disregard to the fact that it may, 1, impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding, a dangerousness hearing, a motion hearing, a trial, or other criminal proceeding, yada, yada, right? And there's some pretty stiff potential sentences. All right. So we got a pretty beefy thing. Now, the next thing that I think we should talk about is, let's see if I could find it. Was it it wasn't that. It was it O'Brien? No, it was not. It was, there you go. All right, so this is Commonwealth versus Tebow. Not Debo, Tebow. To convict a defendant of witness intimidation, the Commonwealth must prove that, number 1, so these are the elements the Commonwealth has to prove. Number 1, a possible criminal violation occurred that would trigger a criminal investigation or proceeding. So they have to show, which they did in the complaint, they had to show that there was a potential murder, right? Right? The grand jury indicted Karen Read on second-degree murder, blah, blah, blah. So they had to prove that there was a potential criminal violation. Obviously, there is a potential criminal violation because she's been indicted, right? 2, the victim would likely be a witness or potential witness in that investigation or proceeding, or was a family member of such. All right. So the investigator obviously would also apply in here, and his wife would be a family member, and the investigator already was a witness, but other people might be witnesses, right? Number 3, the defendant engaged in intimidating behavior as defined in the statute toward the victim or victim's family member. And that is the misleads, intimidates, or harasses. And you also have harass, to engage in an act directed at a specific person that seriously alarms or annoys such person. So misleads, intimidates, or harasses. So intimidates and or harass is probably going to be of import. And then where we go. And then 4, the defendant did so with the intent to impede or interfere with the investigation or proceeding, or in reckless disregard of the impact of his conduct would have in impeding or interfering with the investigation or proceeding. So he had to either do so intending to interfere with it or do so with reckless disregard. Like he should have known that his actions would impede or interfere with it, right? So back to this. During the investigation into O'Keefe's death, witnesses were identified, interviewed, and testified before the grand jury. So the state is already establishing that these people not only are potential witnesses, but they actually are witnesses. You have Matthew McCabe, Jennifer McCabe, Brian Albert, Julie Albert, Chris Albert, Colin Albert, and Juliet Nagel. On April 2023, Read's defense attorney filed defendant's motion for an order pursuant to Massachusetts Rule of Criminal Procedure 17, directed to Brian Albert, Verizon, and AT&T, alleging police misconduct and conspiracy, yada, yada. A local blogger, Turtle Boy, has adopted defense's claims. Turtle Boy runs a series of websites, yada, yada. Beginning in April of 2023, Turtle Boy began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses, members of their family, and friends. This is just background. This isn't really like much use. He authors and publishes a blog. It has a series of articles called Canton Cover Up, and at least 164 articles have been posted to the website under this category. So he is what you might want to call obsessed. And maybe he's just trying to, it maybe just generates a lot of income for him, and that's what's driving him to do it. I don't know. But these are what we're going to start seeing as the actual kind of material allegations where the state believes that he has violated that particular statute. Kearney posts weekly videos to YouTube where he's discussed Karen Read and made statements regarding witnesses. Below are a small section of verbal statements made by Kearney in these videos that have been published to followers and are publicly available for viewing without being a subscriber or follower and have been archived by investigators. Episode 594, Turtle Boy returns to Canton. This is not my last trip to Canton. I will be back. I'll be back. Get used to this. These people think I'm fucking around. You haven't seen the last of me. Get used to it. Get used to it. Is that intimidating? That's a great question. It sure could be, and I think that would sort of be up to the finder of fact. Episode 598, breaking. Karen Read defense files motion to recuse. This guy, Chris Albert, has his head on the swivel looking for turtle riders. I've got bad news for you, Chris. I got really bad news for you. They are literally everywhere. You guys should just stop going out in public. You guys should just stop going out into public. It's only going to get worse from here. I know where y'all were today. You were in Agawam, weren't you? You guys were at some sort of little league thing in Agawam. Alberts, McCabe's, all you people were there. Just know that there will be no life as normal is over. Life as normal. You had a normal for a while there from January 29th to about April 2023. You guys literally got away with murder. While discussing a video of Chris Albert at being confronted outside of a Canton restaurant, Kearney and his audience, are getting them, speaking about Chris Albert and the other witnesses. When you act this way, that's like a green light for me, time to hit the gas. Then he also says, I've got pictures of you. You can't leave the fucking country. Turtle Riders, we're going to find you. They're going to find you. You can't hide anymore. Your private life is officially over. Over. You leave your house, you're going to have your picture taken, so you're going to get used to the new normal, your new normal. Turtle Riders are going to take pictures of you, and they're going to send it to me. You're famous. We need to accelerate it. They, woman who recorded video of Chris Albert confrontation, are doing a fantastic job with this. Well, so here's the problem for you, 13 Kings. The problem is that when you start stacking up this amount of statements, the context starts being shown by the number of statements made. Courts and jurors aren't stupid. They can piece together things. It doesn't have to be overt. It can be implied. Threats, intimidation, harassment can be implied. On September 13th, 2023, Kearney posted a blog entitled Canton Cover Up, Part 142. So this is not a video, apparently. Free Karen Read billboard goes up on Route 1 outside Gillette Stadium in Foxborough. 2 more to follow on his website. The topic of the blog post was about a billboard that read Free Karen Read with a picture of Karen Read. Kearney praised the organizers of the billboard. In the post, Kearney wrote, "Thank you to everyone who donated as well. Although millions of people know about the injustice that is happening in Norfolk County, I would bet that over half the population of Norfolk County has never heard of Karen Read before. That will change because of this 3-pronged billboard blitz. It's really important for people in Norfolk County to know about this story because it's where the jury pool would be chosen from." Now, let's go over that for a minute. So this is a United States Supreme Court case. This case doesn't specifically deal with it, but it references things that do deal with it. This is Nebraska Press Association versus Stewart. The Sixth Amendment, in terms, guarantees trial by an impartial jury. It really means trial like a fair trial. You're entitled to a fair trial, or at least as fair as you can get, and as impartial of a jury as you can get. Because trial by jury in criminal cases is fundamental to the American scheme of justice, the Due Process Clause of the 14th Amendment guarantees the same right in criminal or in state criminal prosecutions. In essence, the right to a jury trial guarantees the criminally accused a fair trial by a panel of impartial, indifferent jurors. A fair trial in a fair tribunal is the basic requirement of due process. In the ultimate analysis, only a jury can strip a man of his liberty or his life. In the language of Lord Coke, a juror must be as indifferent as he stands unsworn. His verdict must be based on the evidence developed at the trial. In the overwhelming majority of criminal trials, pretrial publicity presents a few unmanageable threats to this important right. But when the case is a, quote, sensational, end quote, one, tensions develop between the right of the accused to trial by an impartial jury and the rights guaranteed others by the First Amendment. The relevant decisions of this court, even if not dispositive, are instructive by way of background. Irvin v. Dowd, that was an issue where the court overturned his conviction because the venue change was denied. Rideau versus Louisiana, there was a highly emotional confession that was there for 3 days prior to trial, and so that was going to taint the jury pool. And then Estes versus Texas, which is probably one of my favorite cases. The court held the defendant had not been afforded due process to the volume of trial publicity, the judge's failure to control the proceeding, and the telecast of the hearing and the trial itself inherently prevented a sober search for the truth. So this is showing kind of his intent. His intent is to deny Karen Read a fair trial by an impartial jury. This is establishing intent. This is not one of the elements of the witness intimidation. This is really showing intent. And I like Estes versus Texas so much that there is a specific court proceedings are held for the solemn purpose of endeavoring to ascertain the truth, which is the sine qua non of a fair trial. Sine qua non means like the essential element of. It actually means without this not, or something like that. My Latin is terrible, but it essentially means that the court proceeding, the sole purpose, the essential element of a court proceeding is to discern the truth in a fair trial, right? Over the centuries, Anglo-American courts have devised careful safeguards by rule and otherwise to protect and facilitate the performance of this high function. As a result, at this time, those safeguards do not permit the televising and photographing of a criminal trial, yada, yada. This is weighty evidence is that our concept of a fair trial do not tolerate such indulgence. We've always held that the atmosphere essential to preservation of a fair trial, the most fundamental of all freedoms, must be maintained at all costs. So the issue with the most fundamental of all freedoms, your right to a fair trial trumps someone else's right to the First Amendment. It is the most fundamental of all freedoms. If they strip your right to a fair trial away, all the free speech in the world won't save you. I don't give a shit. And I love your titties, by the way. I love your titties. You have awesome titties. Don't let anybody take those away from you. All right, so, and I'm sure that Aiden will show up now that Kate has made her presence known to tell me how wrong I am. All right, so that's what number 8 is going to. Number 8 is going to his intention. It's showing that he is exhibiting a pattern of intending to influence the trial, and that goes to one of the things that they have to prove, which was in Thibault, that the defendant did so with the intent to impede or interfere with the investigation or proceeding. They're showing intent. I don't lie about titties. So bite your tongue. Or in reckless disregard of the impact. So, but what that's showing that he is intending to mess with the proceedings. So number 9, on June 13th, 2023, Kearney broadcast a live YouTube video, episode 590, which is currently posted on his YouTube page. During this broadcast, Kearney displayed the phone records of Jennifer McCabe from the day O'Keefe was killed. These records displayed names next to phone numbers which appear to be the user of the other phone number. These records had previously been an attachment to an unredacted defense motion in Commonwealth versus Reed. During the video broadcast, Kearney cold calls the phone numbers without names associated. In this process, he called the work cell phone of Trooper Proctor, who we've already established is an investigator, and we've also established that he is a witness or a potential witness. Well, he is a witness because he's testified, right? Trooper Proctor stated the phone number that was called. Kearney left the following voicemail. Hi, Trooper Proctor. This is award-winning journalist Aidan Kearney calling. Like, why do you have to, if you're famous then you don't have to tell people that you're award winning. If you have to tell people that you're award winning, small dick syndrome. I'm calling to talk to you. I do have some questions about you. I have a lot of questions, actually. For starters, why didn't you tell me, one, before the investigation, that you were good friends with the Albert family? Why did you, in your report, say that you were introduced to Chris Albert on February 10th when you have known him for more than a decade prior to that? Why did you lie about the time you towed Karen Reed's car? Why did you intentionally misspell the names of several key witnesses in your report? And I'm just wondering about all those things, and maybe you and I can meet up for coffee. Now, none of this in and of itself, right now, as it stands, as alleged, but we'll get to it, is witness intimidation, right? Boy, do I have a lot of questions for you. When you were inside Fairview Road that night, or that morning rather, why did you stay there for 4.5 hours? And what did you guys talk about and do? And why were you descending stairs with John O'Keefe's phone in your pocket? So give me a call back, man. We feel like you and I have a lot of catching up to do. I talk about you a lot. So now it's starting to get a little, I talk about you a lot. Now, why are you saying that? I feel like I know you pretty well at this point. I know what year you graduated from your academy. So what are you trying to say? What are you trying to say? Why are you bringing up things about me, personal things about me? What are you trying to say? What are you intimating? I know you were out in West Brookfield for a while. I know some people that you know. So give me a call back when you get this. What are you intimating? Now that I have your phone number, and everybody watching also has your phone number, there you go. Like, now it's call flood time, right? Call flood. Intimidation. I'm going to make your life miserable unless you do what I want you to do regarding the trial. Affect the trial. And then he states, again, the number. She called you again. You called her at 12:49. We're going to get to that. So now that I have your number, I'm going to plug you in and we'll talk soon. Again, like, what are you trying to say? As a result of the cell phone number being broadcast, so not only was there basically a statement that I will try to intimidate or harass you, now there's actual harassment. Trooper Proctor began to receive random and harassing text messages and voicemails. In the 12 hours following Kearney's calls, Proctor received approximately a dozen text messages, phone calls, and voicemails. I don't know, a call or text message an hour? I don't know about that. Is that really a lot? Well, yeah, but I'm not smart. I'm only a first-year family law attorney. The content of the calls, I don't know if one call an hour is really a lot. The content of the calls and messages pertaining to Proctor's alleged involvement in the conspiracy and calls for his termination. That's where it might be harassing. Proctor had to change his work cell phone number to avoid the constant unwanted calls and messages. Again, 12 in 1 hour. I'm not entirely sure about that. Proctor is married to Elizabeth, and he wrote blog posts about Elizabeth Proctor. Why the fuck, Aidan Kearney? Why the fuck would your dumbass write about Elizabeth Proctor? Why would you write about the family of the trooper that was investigating? Why would you do that? Why the fuck would you do that, dude? You dumb fuck. A video is attached to the post. Video depicts a cell phone screen of an Apple iPhone. The user of the cell phone dials the cell phone number of Elizabeth, which is displayed on the screen. Kearney further writes, I can think of two people who deserve to lose their jobs over this alleged conspiracy, though. Michael Proctor and Elizabeth Proctor. These two lowlifes think they're untouchable. They're nothing but bullies who terrorize people for years, but now they've met their match. In the post, Kearney states Elizabeth works as a human resource manager at Instron and posts the main phone number for the company. You know who else does shit like this? Coded. Coded also posts shit like this. Because he's a fucking douchebag. Fuck that dude. Then, and the post then states, but you're probably not going to reach anyone that way, so feel free to leave a review on their wide open Facebook page or their Twitter account. Call floods, etc. Dude, stop simping, 13 Kings. Like, I don't fucking care, dude. Calm your emotion, cool your tits. We're going through the complaint. He'll have his day in trial in court. He'll be able to prove these things, if true. But you don't get to harass people just because you think that they're Facebook friends with somebody else or whatever. And you need to cool it too, Kate. Don't fucking engage him, please. I love your titties, but titties only go so far. On May 10th, Kearney posted a live YouTube, which is essentially posted on his YouTube page during a broadcast at the 106. You don't care about the truth. Leave Brittany alone. You fucking twat waffle. Jesus Christ, dude. Can you pull Aiden's dick out of your mouth for just a minute? You're choking and your brain needs oxygen. Jesus fucking Christ. Oh my God. You look like, dude, 13 Kings, you look like a bitch. You look like an absolute bitch. Christ. I'm gonna white knife for Aiden because he's really short and he needs me to protect him from the mean words on the internet by a guy reading a complaint. No, Paul. You can't rush perfection, sir, and or madam. You can't rush perfection. And you're the one who got me all the documents and asked me to do this, Paul. So you get what you get. You get what you pay for, Paul. How much did you pay me? During the broadcast, he talks to Elizabeth. He said he was going to call her. He repeated her cell phone number on the broadcast. As he was entering the number in the phone, using the speakerphone option on a cell phone, he broadcasted the phone call. The phone call went to voicemail. She said the phone call came from that particular phone number. Kearney left the following message. Hey, this is Aiden Kearney calling you back from Turtle Boy. We briefly spoke on the phone. I introduced myself to you, and then you hung up on me, or maybe it was a bad connection, but I wanted to see how your day at work went today, if it went well. He's following up, basically saying, I'm going to make your life miserable. I'm going to have my fans go to the the Facebook and Twitter page of the company that she works for to harass them, etc. Oh no, thanks for letting me know, 13 Kings, because I totally would have missed your dumb ass. And stay gone. Don't let the door hit you where the good Lord split you. So he was basically saying that he was responsible for some disruption and hoping that the disruption actually made it to her at work. I noticed your employer took down their social media pages within minutes of the blog I published about your recent behavior. I just wanted to see, what is it awkward? Were you afraid to go in? See, he's trying to intimidate her. Like, this is all out of context, says 13 Kings. This is out of context. There's a whole fucking paragraph, not a cut in it. Out of context? I don't think so. They gave you the whole fucking thing out of context. Just tell me about your day and why, because that's the part I don't understand, is that you seem to be okay with calling other people's workplaces interfering with their ability to make a living for themselves. But what happens to you, maybe it's not as fun. Maybe it's not as fun. Do you like that? That's what I want to know. Did you like that? Because you've been doing that to a lot of other people. And do you think it's fair that it happened to you, dear? Do you regret it? Do you regret it? Well, here's the difference, Turtle Boy. Here's the difference. If you think that she's attacking you, you're not a witness or a potential witness. Nor are you related to a witness or potential witness. She, however, and this is going to shock you, is related to not only an investigator, but a witness. Oopsie fucking doodles. And what's your scumbag husband up to right now? Are you going to visit him in prison? Do you think they'll have conjugal visits? Give me a call back when you get this and we can chat some more. Bye, girl. Just calling her to harass her. Just harassing her. Following the phone call, Kearney accessed the social media accounts of Instron and laughed as he said the pages were taken down and said the Turtle Boy effect. Oh God, he's claiming responsibility for harassing her, right? Or directly or indirectly harassing her, right? Both Michael and Elizabeth Proctor say they have felt harassed by the acts of Kearney. Imagine that. Fucking shocking. On Monday, September 25th, 2023 at 6:26 p.m., a Facebook account believed to be used by Kearney Clarence Woods Emerson posted the following message. Anyone in Canton want to take a couple of pictures for me? DM me, please. At 6:53, the Facebook post is edited with the phrase, update, all set, thanks. On September 25th, 2023 at 8:04 p.m., from X account, formerly Twitter, associated with Kearney, posted this message and photograph. The photograph depicts the front of 6 Wentworth, depicts the address of Michael and Elizabeth Proctor. The white Jeep Wrangler in the photograph belongs to Jennifer McCabe. So this is the post today at 6:26 p.m. It was seen, Jeep was seen parked outside the Proctor household. We ran the plates on all 3 cars. Why the fuck are you running plates, homeboy? And why the fuck are you bragging about it? What kind of a dumb motherfucker are you, sir? The registered to these people, and the DA's office says they don't know each other. Well, they maybe not. I mean, when the DA's office obviously had been contacted in the past compared to where they are now, right? So in the past, they didn't know each other, but now apparently they do. Weird how that happens. And I would just like to point out, Michael Proctor is an investigator, and Jennifer McCabe is, on information and belief, a witness. Jennifer McCabe was interviewed by investigators. See, the lead investigator is Proctor. And Jennifer McCabe was interviewed by investigators. Guess what? Now they know each other. You dumb shit. You dumb shit. It's all a conspiracy. It's all a conspiracy. Fucking hell. Did he? Did he have a dispatcher on his team to violate the law? I mean, basically, he just advertised that. He has somebody. Somebody is violating the law by running these plates for non-law enforcement purposes. So, oh my God. I know, he just established that, and he bragged about it because he's a fucking retard. Oh my God. All right. The following day, he broadcast a YouTube video at the 19-minute mark. He said he ran the plates of the vehicles depicted in the photograph. Kearney showed photographs of 3 vehicles parked at the address. He showed photographs of each vehicle and said the registered owners of the vehicle by name. The term ran in regards to a motor vehicle registration is commonly used in law enforcement. The term means the information was queried through law enforcement databases for purpose of obtaining information. Kearney used the information in a blog post entitled Canton Cover Up. In my best guess, and you could tell me how fucking dumb and wrong I am. Maybe MSG retired would know, maybe he wouldn't. In which case, you could tell me, or any other law enforcement officer. But my guess is that if someone runs a license plate, there is a record of it somewhere. And Kearney established that he had someone run the plate. And my best understanding is that they would be able to find out who ran those. And so there you go. That's my best understanding. So somebody probably at least got in trouble, maybe not lost their job over this because fucking Turtle Boy can't protect his sources to save his fucking life. Like, it's just not smart. He's so wrapped up in this, whatever it is, that he's just acting really fucking stupid. We and audits of inquiries. I don't know what that means. I'm assuming you're using text to speech, but it's not working for you, Felipe. Information obtained by the, okay, here we go. Information maintained by the Massachusetts Registry of Motor Vehicles, accessible to law enforcement through CJIS. Authorized individuals have personalized access to CJIS logons and accounts. There you go. Recertification standards, which include law lessons and tests, continuously assert CJIS users are trained to do standards that do not disseminate protected private information unless for a legitimate law enforcement purpose. And so there you go. Oh, well, here we go. Name and shame. Name and fucking shame. On Tuesday, September 26th. Congratulations, Turtle Boy. You're a fucking retard. Congratulations. On Tuesday, September 26th, Lieutenant John Fanning of the Massachusetts State Police conducted a CJIS audit, determined if any CJIS user queried the following Massachusetts registrations. That audit produced results indicating all 3 vehicles were queried by Janelle Webb's CJIS account. Janelle Webb is employed as a civilian dispatcher with the Avon Police Department. Oof. Oof. Congratulations on getting your your source fucking, I'm going to assume she's at least been somehow sanctioned, if not fired. Maybe even it's criminal. I don't know, but it's probably not good. On Wednesday, the officers interviewed Webb at the Avon Police Department. Webb said she'd been employed as a dispatcher at the Avon PD for 3 years. She was working on Monday, September 25th from 4 p.m. to midnight. She said she communicates on Facebook Messenger with the account Clarence Woods Emerson, which she believes is used by Kearney. She said she sent Kearney information prior to September 25th and has seen the same information used by Kearney on his blog. She provided her cell phone to investigators. Investigators observed communication between Webb and Clarence Woods Emerson on Facebook Messenger on the cell phone. On September 25th, Webb sends a message, "What you got? I'm here till 8 a.m." Clarence responds with, "Sorry, H." So the registration of McCabe's Jeep. After several messages back and forth, she sends a message, Matt McCabe, to which Clarence responds, "Got him!" and is parked at Michael Proctor's house as we speak. It thinks this is huge. Webb responds with a message, and please keep me private. I don't anticipate fucking up in life, and I never want the wrath of you. Ooh. I don't anticipate fucking up in life, and I never want the wrath of you. What does she mean by that? What do we not know about this? That piques my curiosity. Is he, does he have something on her? Does he have something on her? Sunny asks her to run 2 more, and then she responds back. She stated she's read Turtle Boy posts in the past and been following his media regarding Karen Read closely. A check of Webb's Facebook account information publicly available revealed she is friends with Clarence Woods Emerson. Webb has numerous posts and comments on content on Facebook supporting Reed's innocence and copying Kearney's claims of police cover-up. On YouTube video, Kearney acknowledged it is illegal to obtain information about the registered owner of a vehicle and discussed why it should be legal. So he knew, or should have known. Jesus Christ, this guy is fucking like, oh. Well, I guess I'm in for hell. So whatever. He can come at me, bro. Come at my face. Wait, what? Sorry. Did I say that out loud? I interviewed Jennifer McCabe regarding the incident. She stated she had never met Elizabeth Proctor or Michael Proctor prior to September 2023. Since the first meeting several weeks ago, Jennifer and Elizabeth have communicated regarding the constant harassment, intimidation, and public attacks. So September 23, they met. Great. There you go. Jennifer said they bonded over sharing the ongoing experience. She traveled to Elizabeth's house to discuss harassment. Based on the foregoing facts, there's probable cause to believe that Aidan Kearney committed a violation of Massachusetts General Law, Chapter 268, Section 13B, where they read the statute. Based on the foregoing facts, there's probable cause to believe that Aidan Kearney committed a violation of Massachusetts General Law, Chapter 274, Section 7, conspiracy to commit intimidation of a witness by entering into an agreement with Janelle Webb to obtain sensitive information to be used in blog posts and videos intended to harass, intimidate, and cause emotional harm. This is the conspiracy one. There's not a lot to it, so I'm not going to go over it. And given the continuing harassment of witnesses for the murder of John O'Keefe, I respectfully request an arrest warrant be issued. So now I'm not knowledgeable. I'm not knowledgeable about Massachusetts criminal procedure. I'm going to assume that if this is a complaint, that either there was a subsequent indictment or there was some sort of a probable cause hearing. I'm not sure. But there would have been some finding either by a grand jury or by a judge that there was probable cause. So my understanding is that 268.13b is a felony because it has rather substantial potential state prison by not more than 10 years. Yeah. I think that's 2.5. I think that's 2.5 years, not 21 halves. Well, that'd be for the arrest warrant. That'd be for the arrest warrant. The I don't very often read my emails. If they're just sycophants sending me sycophant emails, I usually just glaze over. So the arrest warrant would be a different probable cause. So this is, so I don't know if you can see it, but this is titled as a complaint, and this is filed or received by the clerk magistrate. It might be just the it might just be for the arrest warrant. It's titled complaint, so I'm not entirely sure. But if so I don't know. I don't follow this. I don't follow this. I have read previously. I previously read the memorandum and order on defendants' bail petitions. That's all. That was the entire amount of my knowledge about this until last night when I was sent the other documents. So I don't know what stage this current trial is at, other than the fact that there has been there's been a bond hearing, a bail hearing, and I would assume that before it got to that point, or relatively shortly thereafter, there'd be a probable cause hearing. Right. The magistrate found probable cause, right? But so even in California, an arrest warrant. So maybe Massachusetts is totally different than California, but in California, they'll get the arrest warrant based on a probable cause, an affidavit submitted to California. We just use judges and commissioners. We don't have magistrates, and that will get you the arrest warrant. But then after the arrest, if there is no grand jury indictment, there will be a probable cause hearing, basically like a mini trial, where the judge will determine if there is probable cause to proceed on the various causes of action. So whether or not there was a arrest warrant issue doesn't mean that in the actual like criminal case itself there should be a probable cause hearing of some sort, or an indictment of some sort. Yeah, Massachusetts is fucking weird. Yeah, indeed. All right, so the next thing we have is this is the petition filed by Turtle Boy's attorney. And I haven't read this. I just got this morning. I have not read this at all. So you should take that with a huge grain of salt. So they cite the Massachusetts Declaration of Rights, Article 16, the liberty of the press is essential to the security of freedom in a state. It ought not, therefore, be restrained in this Commonwealth. The right of free speech shall not be abridged. Most states in Commonwealths will tie in their constitutional rights to the federal interpretation of rights. And I'm going to assume, unless someone tells me otherwise, let's see, these are felonies, so that doesn't apply. So then the United States Constitution, Congress shall make no law respecting the establishment of religion, prohibiting the free exercise thereof, abridging the freedom of speech or press, or the right of the people to peaceably to assemble and to petition the government for redress of grievances. Now, normally, well, usually, yes, the federal is the floor, but normally, in my experience, having looked at a lot of state constitutions for the purpose of doing my channel, and seeing the way they interpret their various provisions, because states will normally have provisions on free speech and on freedom from unreasonable search and seizure and things like that. And generally speaking, the court will just say, "Oh, our version, the state version of this constitutional amendment is to be basically defined the same as the federal one." So I'm going to continue with assuming that the state's interpretation of freedom of speech and of the press is going to be read in a way that is identical to the way the First Amendment is interpreted. Now, freedom of the press, generally you see freedom of the press litigated as freedom of access, as a right of access. So I'm not sure how well, again, I haven't read this. I'm not sure what kind of an argument they're going to be able to make that there is some extra right to intimidate people or harass people or otherwise generally threaten people. If that, I didn't see any allegations of threat. So we'll see if they differentiate it in here. All right, now comes the petitioner, Aidan Kearney, a professional member of the press. I don't know what that means or why. Maybe they'll develop it. But okay. And hereby request the Superior Court to review and vacate the. So my understanding of Massachusetts is their district court, generally speaking, will handle misdemeanors and some felonies, and the Superior Court will handle like the big boy felonies. That's my understanding. I could be wrong. Again, I have next to no understanding of the Massachusetts criminal procedure rules, and thereby request the Superior Court review and vacate the release determination of Slotin District Court in 9 criminal actions brought against him on First Amendment and overbreadth grounds. Now, another issue that generally speaking, you can always waive your rights. And what the court can do, or what the prosecution can do, etc., is say, we'll let you out on bail or bond conditions, or we'll agree to bail or bond conditions that have these terms in them. And some of the terms are pretty onerous. Like you have to, like, basically cops can search you at any time for any reason, stuff like that. Like you basically waive your Fourth Amendment right to be free from unreasonable search and seizure. And that's been upheld almost routinely. I don't know of any situations where that hasn't been upheld, because you had a choice. You can sit in jail. You do have a right to bail a bond, but you could choose to sit in jail, or you could choose to agree to their terms. So usually any term of bail or bond is going to be upheld because you waived it. You chose to accept that term. Mr. Kearney has the right to a new determination of bail by Superior Court under this particular section. Superior Court shall, in accordance with the standards set forth in the first paragraph of the section, hear the petition for review as speedily as practicable, and except for unusual circumstances, on the same day the petition is filed, provided, however, the court may continue the hearing the next business day if the required records and other necessary information are not available. The justices of the Superior Court may, after a hearing on the petition for review, order the petitioner be released on bail on his own personal recognizance without certity or in his discretion to reasonably assure the effective administration of justice, to make any other order of bail or recognizance, or remand the petitioner in accordance with the terms of the process by which he was ordered committed by the district court. So what they're saying here, so Kearney already had own recognizance. He just had to comply with certain conditions. So the statute that they're citing to says that he could be released on his own recognizance without surety, OR, or the court can make any other order of bail or recognizance that they need to, or they can remand the petitioner in accordance with the terms of the process by which he is ordered committed by the district court. So there's 3 options: OR without anything, with whatever order of bail or recognizance necessary, or stay in prison or jail. Stay in jail until trial. You get. Did I misstate recognizance? Sorry. Yeah, 4 syllables. Yeah, you're right. Good job. Are people getting heated? We'll get to them. Mr. Kearney was released on personal recognizance, but was subject to 8 orders. The stay-away orders restricting his future speech. Did it restrict his future speech? That's a good question. Can we go over Kate's charging documents next? I mean, there hasn't been a lot of drama about those. And again, I really didn't want to cover this, but I can see what team you're on, dumb truck. I can see what team you're on. If you could make a good argument, dumb truck, I'll make you a deal. You make me a good argument, because this is why I'm going over this. It's because it's First Amendment related, and the argument was made that I should go over it on First Amendment grounds. That I should go over it and look at it because of its impact on the First Amendment, or so the argument was made. If you could make me an argument that Kate's charging documents are related to the First Amendment and that there is a good First Amendment issue, that other channels have gone over it and have come away with a different, because I read the court's order and I'm like, yeah, it seems like a perfectly reasonable order, but I was told that other channels have gone over it and thought that it was overbroad. So if you could make me a good argument as to why Kate's charging documents are similar to Turtle Boy's in that they address First Amendment issues, and that other YouTube channels lawyer YouTube channels have looked at them and thought, oh, hell yes, brother. Hell yes. Kate, we're going to go over your nudes next. So if you can make an argument that it's similar to, well, then there you go. So I'm not going to cover it. I don't cover consistent violations of HBOs. So take a big, long go fuck yourself. So he's released on personal recognizance, but subject to 8 orders restricting his future speech. That's the argument they're making. An ability to be present at locations where the 8 listed victims may be found, and warning may be sentenced up to 90 days in jail for direct or unspecified or undefined indirect contact with these individuals. The Superior Court has the authority to address these conditions of release as well as cash bail or Section 5A conditions. See Commonwealth versus Madden. Conditions of release may be reviewed by the Superior Court judge. The 8 individuals are people Mr. Kearney is reporting on in connection with pending Norfolk County murder case out of Canton, Massachusetts. Each and every one is either directly involved with the matter or has inserted themselves into the case, making them fair subjects of inquiry. I don't know if you know this, Aaron, but Kate doesn't like me. So, and I'm not hanging my hat on Kate banging me. My wife might object to Kate banging me. Kate's boyfriend / live-in abuser might also object to Kate banging me. So I don't think you're reading the room well, Aaron, because you're a fucking retard, sir and or madam. Mr. Kearney is an award-winning, muckraking dude. I don't get nudes either, bro. So like, you know, you and me both, kid. I'm over here blue balling it like the rest of them. Mr. Kearney is an award-winning, muckraking investigative journalist operating his own news network, Turtle Boy Daily News. You know, all of the best award-winning, muckraking investigative journalists name themselves things like Turtle Boy. I don't know why I clicked that. Absolutely. Mr. Kearney's and social media accounts where he prolifically reports on items of public interest and public concern. He repeatedly scoops major news outlets and provides blah, 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 blah. The gravamen of the court complaints concerns Mr. Kearney's acts of indisputable journalism. Clearly, it was journalism. Clearly, it was journalism. Indisputable. Clearly. Patently. Clearly. Showing up at the individuals' houses and sports events for the purpose of questioning them, calling them, and following them, seeking comment, and speaking out directly to them on his show, all to question them about a currently pending Norfolk County murder case. There is no doubt he's addressing matters of public concern as a professional journalist. Grotesquely, the Norfolk County District Attorney has sought to transform these time-honored journalistic tactics for news gathering into felonious witness intimidation. he hired a special prosecutor and brought 9 cases against Mr. Kearney, unauthorized search warrants to seize the tools of Mr. Kearney's trade, and arbitrarily and capriciously characterizes journalism as threats and intimidation. Well, I don't know. I didn't see a whole hell of a lot of journalism going on when he was directing people to call flood or to bomb social media for someone's work. I didn't see a lot of journalism going on there. But maybe I'm just fucking retarded. As evidenced in his affidavit filed herein, Mr. Kearney is experiencing a pronounced chilling effect on his ability to continue to cover a story. He has submitted over 180 stories on the murder prosecution referenced above and is trying to function as a professional investigative reporter under prior restraint on his speech. Prior restraint is where you have information and you're not allowed, the government is not allowing you to disseminate that information. That's what prior restraint is. You have information and you want to say that information, and the government says, no, you can't. Classic examples of prior restraint are gag orders, where the court will allow you to attend the trial, but says you can't publish anything on the trial until I say it's okay. So now you have all this information, but you can't talk about it. That's prior restraint. Prior restraint is basically where or another one is where if you want to publish a book, like let's say you work for the government and you want to publish a book, and the government says, you have to give us your book prior to publishing it so that we can go through it and we can redact any potential matters of top secret matters, right? So before you can speak, the government gets to silence you, gets to censor you. And that's the important thing. It's where you're not being punished after you've done something wrong. You're being prevented from doing something which the court doesn't know yet in advance may or may not be wrong, right? So the book that you have that you want to publish may not have any top secret information, right? So the court or the government, by making you submit the book to them, is basically preventing your speech prior to them knowing if you've done anything wrong or not. The gag order on the journalist, they can't say anything about the trial until the court says it's okay. They may something that is, the court will usually have some justification for it, like, oh, it's sensitive, we don't want to leak witness information, blah blah blah, right? So the court says you can't publish anything about this prior to me saying it's okay, and what you might have published might not have done anything to threaten the witnesses or whatever, right? So if the court was not allowing Turtle Boy to cover the topic, that would be prior restraint. Sure. But they're not. There's been no order that I have seen that prevents Turtle Boy from covering the topic. He can't contact those 8 individuals. He can't go to where those 8 individuals are. Get it? That's different than not allowing him to cover it. So this is again not prior restraint. The district court has essentially given these 8 individuals veto power over Mr. Kearney's reporting by allowing them simply to not show up at any venue, any public place, any courthouse relevant to Mr. Kearney's reporting, and flush him out, evicting him at will under risk of 90 days incarceration. Well, so one of the things that is punishable, and it would be under contempt, right? 90 days of contempt. I haven't seen the actual. No one ever gave me the actual bail order. I'm assuming that this is some sort of a contempt action for direct or indirect contempt. And part of what they would have to show, part of this is that he knew or should have known that these people would be there, right? That's what he'd have to show. Or that's what the state would have to show. I mean, like if Turtle Boy is like shopping at his normal supermarket and he turns a corner to go down the produce aisle and boom, right there is Proctor, right? Has he violated the no contact order? No. But as soon as he knows, he has to leave, right? because now he knows the guy's there. So is that a veto power? No, not necessarily. But I mean, how else could the government protect those 8 people from Turtle Boy without saying that you can't be within, like, you can't contact these people or be within a certain distance of them? I'm assuming it's a certain distance that he has to stay away, right? I don't think like if they're going to go to what's that sports ball team in Massachusetts that has a big stadium, the Patriots or something like that. So if if one of these 8 people go to watch a Patriots game and they're sitting on the opposite side of the stadium from Turtle Boy, I don't think he's violating the court order. I don't think so. I mean, I haven't seen it, but I can't imagine that. Yeah, exactly, Top. I can't imagine that they would have written it so broadly that a venue, right? Like what if he goes to, like, what's a real big venue? Like, what if he goes to the mall in Washington D.C., right? He goes to the mall. That's huge, huge park, right? Huge city park. Technically, Washington D.C. park, but it's huge. It's enormous, right? And yeah, and so I mean, would that be a venue? Like, would he, if there's someone at the Supreme Court, if Kearney's there at the Supreme Court steps waiting for an interview with someone coming out, and at the other side is the Lincoln Memorial? If one of these 8 people are down at the Lincoln Memorial, would he be in violation of the court order? Probably not. So see, they're saying venue, but I seriously doubt that they mean any venue or any public place. I'm sure it's something like, they didn't specify distance at first. So now they have, right? Because I would say that it would be impermissibly vague if they just said at any venue or public place, right? Well, unenforceably vague, I should say, unenforceably vague. So the court probably would not be able to convict him of contempt, because in order to be convicted of contempt, you have to be able to understand the order. The order has to be clear enough that you can abide by the order. There you go. If Mr. Kearney is not sure if even referring to the individuals should be construed as indirect contact in light of the court's comments to him. Well, I don't see why that would be, but if he's directing his people to go and contact them, that would be indirect contact. The district court advised Mr. Kearney that the stay-away order was broad on purpose, and that should Kearney violate it in any way, he would be subject to being held without bail. So I can't tell you the number of times people suggest or imply that restraining orders, civil harassment restraining orders, domestic violence restraining orders, emergency protective orders, etc., HPOs, TROs, whatever. I can't tell you the number of times people think that those are impermissibly, they impermissibly violate the First Amendment, and they don't. Like, number one, in this particular case, Aiden had to agree to it. He had to agree to it. He had to sign the little piece of paper agreeing to it, to the bail condition, or else he would have had to stay in jail. Yeah, but he had to agree to it. Number two is, it's restraining orders like this. I've dealt with them all the time. They are constitutionally permissible. Are you cold and wet, buddy? Are you cold and wet? Poor boy. I'm going to see if the dog wants inside. He looks a little wet. All right, I took the opportunity to avail myself of some liquid refreshment. All right, so CEG, blah, 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 he's charged with blah, blah, blah. The fact the court engineered or brought on purpose is an unlawful mandate in violation of the First Amendment in Article 16 of the Declaration of Rights. In Commonwealth v. Brangen, Justice Lank summarized a framework under which a state action restraining liberty must be reviewed. The 14th Amendment to the United States Constitution, Articles 1, 10, and 12 of the Massachusetts Declaration of Rights establish a fundamental right to liberty and freedom from physical restraint that cannot be curtailed without due process of law. Pretrial detention encroaches on that fundamental right insofar as it subjects the defendant to government restraint without having received the full measure of due process to which the defendant is entitled to before he or she can be punished under the criminal law. In our previous decisions analyzing the constitutionality of pretrial detention, we have considered two aspects of due process, substantive and procedural, following Supreme Court precedents. Under the test of substantive due process, where a right deemed to be fundamental is involved, courts must examine carefully the importance of the governmental interest advanced and the extent to which they are served by the challenge regulation, and typically will uphold only those statutes that are narrowly tailored to achieve a further legitimate and compelling governmental interest. When a government action depriving a person of life, liberty, or property survives substantive due process scrutiny, it must still be implemented in a fair manner. This requirement traditionally has been referred to as procedural due process. All right, let's look at Commonwealth versus Brangen. .477 Mass 691. Looks like you got the name backwards. Setting bail amount. This is about setting bail amount. So this is an opposite. This is about setting bail amount, right? So you have a constitutional due process right to bail, bond. I'm pretty sure that it was incorporated in the 14th Amendment, right? It's 14th Amendment Incorporation 8th Amendment. Go. So as you can see here in Schill versus Kubel, the protection against excessive bail was incorporated through the 14th Amendment. So states can't do excessive bail. You have a right to bail. So you go out, so you can go out and get whatever you could do the things you need to do so that you could get your defense put together, whether that's earning money to pay for an attorney, reviewing the evidence, whatever. You have a right to bail. Now that's not, it's not a, the right to bail is tempered by the need to make sure that you show up for trial. So a court can deny bail, but it has to make certain findings, right? It has to make certain findings. So the case that he is talking about, Brangen, is talking about bail. Now he was released. Aiden was released to OR. Brangen isn't talking about conditions associated with bail. It's talking about the actual dollar amount bail itself. So it's inapposite. It doesn't apply. It doesn't actually. It's not on topic. It's not on point. It doesn't say what Aiden's attorney wants it to say. Here, as stated by the district court judge, the order is brought on purpose where it must instead be the polar opposite, where a fundamental right is at stake, narrowly tailored to further a legitimate and compelling governmental interest. So again, what they're talking about in here, and I highlighted it, were statutes. Statutes. These are conditions associated with bail. And these, well, first of all, that sounds like narrowly tailored to achieve a legitimate and compelling government interest. That sounds weird. Let's see what Corbin is. Mm-hmm. So this is the statutory provision that applies. A justice supreme, judicial, or superior court, upon application of a prisoner or witness being held under arrest or committed, may inquire into the case and admit such prisoner or witness to bail if he determines that such release will reasonably secure the appearance of the person before the court, yada, yada. So he was already OR. I don't know where we're going with this. Considerations of flight, not dangerousness. We are only concerned here with bail pursuant to this statute as it relates to considerations of flight, not dangerousness. So, so again, this is also an apposite. So like this is 0 for 2 here. He's 0 for 2. Thus, unequivocally, clearly, the order must be vacated for substantive due process violations. Courts allow even domestic abusers under restraining orders and their victims to appear in court together. Well, normally, what this, I don't remember how the court dealt with it, but this argument normally, so domestic abusers both get to show up to court because number one, they're both parties to the domestic violence case, and number two, the alleged perpetrator has a constitutional due process right to appear. Like he's a party. He has the right to appear. Restricting his appearance, I mean, especially in a criminal matter, is very problematic, and the court has to do a lot of fact finding as to what the minimum the court can do and still have that person present. So there's a difference here between the parties and the press. Now, the press don't have any special right of access. What is that? Is that Globe? Is that Globe? Or Brandenburg? Brandsburg v. Hayes. But they don't have a special right of access. The court can restrict the access of the press to be in court. The court can restrict persons from going to court. We've literally seen this with Springer. The court said, you can't come to this hearing. So the court has the power to do that. And again, domestic abusers, they're parties to the action, right? So they can appear in court with the victim because they're a party to it. And, the court, at least in California, the courts take special precautions. They'll typically have a bailiff right there, sometimes between them. Sometimes they'll make the party that is under the restraining order sit kind of like in the corner, even further away from the alleged victim. So it's different at court than it is out in the world where you don't have a bunch of bailiffs around. Here, Mr. Kearney has no criminal record, never threatened violence, never assaulted anyone, and repeatedly implores his fans who show up at speeches and rallies to be peaceful or stay away. He must gain access to courthouses and witnesses to continue his protected activity. No, he doesn't. Again, you don't have any special right to access. The press doesn't have any special right to access over the public. He should be granted the ability to exercise his press freedom to seek to question anyone relevant to the case at hand within the boundaries of the law. This raises the question, what are those boundaries? In a related context, the Supreme Court has addressed what is harassment and what is protected speech in O'Brien versus Borowski. I have that up. That's this case. And so this case is dealing with harassment, civil harassment. This is not dealing with witness intimidation. And this case is dealing with the true threat requirement. And I don't know exactly why I was looking at it. But it's a different statute than what he's talking about. Number one, that's number one, and number two, it's only dealing with the true threat requirement. It's not dealing with the slightly lower, I think, restrictions that are on the witness intimidation. So, and again, what would constitute a violation of a restraining order and what would constitute harassment are two different things. One is what it takes to get the restraining order. The other would be a violation of the restraining order. So once you've done the thing that enables the other person to get the protection, now it takes a lot less for that other person to put the boots to you because you already met that initial burden. You already fucked up. They don't have to wait for you to fuck up again, right? So I don't know why we're talking about this, to be perfectly honest with you. They are now being protected from contact because he was intimidating or harassing witnesses. And again, the requirement is that he do so with the intent to impede or interfere, that he engage in intimidating behaviors defined by statute, and the defendant do so with the intent to impede or interfere, right? It's a great day for ducks. He should be granted the ability to exercise his press freedom to seek to question anybody relevant to the case, cause at hand within the boundaries of the law. So that's kind of weird. Like, what would happen? Just hypothetical. What would happen if a member of the press, like let's say, I don't know who a member, let's say Rachel Maddow. Let's say Rachel Maddow gets in a fight with her, is she married? Wife, girlfriend, whatever, and beats the ever-living piss out of her wife or girlfriend, right? So her wife and girlfriend goes to court and gets a domestic violence restraining order. Now, how far do you think it would take Rachel Maddow if she said, well, look, this is a high-profile case. I want to report on this case. Obviously, I'm a celebrity. Anything involving me is high profile. The domestic violence accusations, highly, it's a matter of public interest. And so I should have the right as a journalist, as a professional journalist, as a professional member of the press, I should have a right to interview my wife or girlfriend, whatever it is, and talk to her about the case because, I'm a reporter. You're chilling my free speech. Imagine how that would play. Or give me another member of the press here. Tucker, somebody or the other. What's Tucker's name? Carlson Tucker? Tucker Carlson. Tucker Carlson. He's married, right? He's a good Christian boy. So imagine he beat the piss out of his wife, right? So both sides can get their mix on. He beats the piss out of his wife, and then he wants to report on it, even though there's a DVRO against him, and she's the protected party. Should he get the right to go out and interview his wife, who he beat allegedly? Should he be like? Do you think that would fly? That's essentially what Aiden is asking for. Like, when I put it in different terms, you can kind of understand why it's really fucking stupid what Aiden's asking for, right? You can get it. I don't care that she's homosexual. Like, I'm in California. I honestly don't fucking care if she's homosexual. But whoever's name you want, I don't fucking care. Just members of the press and a restraining order, right? Fuck. Well, who the fuck cares about the UK? The UK doesn't have a First Amendment, and we fought a war and we beat the UK's ass so that we don't have to play their stupid fucking games of who gets to be a member of the press. So this raises the question: what are those boundaries? Blah blah blah. The court limited. Blah blah blah. Again, it doesn't. It's inapplicable. It's inapplicable here. It cannot be reasonably. Is alleged threats? Did he? I didn't see threats in here. I saw harassment and intimidation. So he's trying to apply O'Brien where it doesn't apply. All right, you're a lesbian. Now what? Oh, I'm sorry. You're a lesbian, damn it. Now what? It cannot be reasonably disputed that Mr. Kearney's alleged threats, which I don't know what the fuck he's talking about, concern ideas and advocacy protected by the First Amendment in Article 16. No. Well, maybe. Well, so number one, it's not alleged threats. Now, does the First Amendment protect him intimidating and harassing? To a point. It would. Except would the fundamental right, the most fundamental of all freedoms, i.e., the right to a fair trial, would that trump the First Amendment? You tell me. The individual's alleged fear must yield to Article 16 of the First Amendment. In fact, it has already found to be lacking in probative force by two district court judges. Two of the individuals sought harassment protection orders and were denied on First Amendment grounds and due to a lack of threats of bodily harm or property damage or absence of fighting words. Again, wrong fucking standard. HPO is going to require fighting words. But they're witnesses. And the court has an inherent power to protect the fairness or perceived fairness of their criminal trials. So you're looking at a case that doesn't apply. You're looking at a situation that doesn't apply. One was denied by the same judge issuing orders here, and another one was by another district court judge. Congratulations. Different standards, different cases, doesn't apply. So HPOs don't require probable cause. So he's fucking wrong. An HPO would be decided on either preponderance of the evidence or clear and convincing. I'm not sure which standard they use. In California, civil harassment or restraining orders, which I think are the equivalent of an HPO, require clear and convincing evidence, which is well above probable cause. Well above. Even preponderance of the evidence, which is what California uses for a domestic violence restraining order, requires preponderance of the evidence, which is well above what probable cause is. Probable cause is something well below preponderance of the evidence. So Aiden is not an attorney, and the other judges would not have ruled on whether or not there was probable cause, and it wasn't before them properly. So even if they did rule on whether there was or wasn't probable cause, it would be immaterial because another judge who these particular thing is before has already properly determined there's probable cause for the arrest warrant. So there is probable cause for the arrest warrant. Whether or not there's probable cause for all the charges, I don't know. I still think there has to be a probable cause hearing based on more than just the allegations, the bare allegations of the officers. Yes, indeed. Yes. Okay. So that was the initial petition. I found it to be very lacking. I don't know about you, but so I'm not judging the attorney on this one. The attorney, I think, did a fine job. It was well written. He made a case, best case he could make, and he's fighting for his client. So here we go. This is the supplemental. So he gets a second bite at the apple. Ugh. Now comes the petitioner, Aidan Kearney, who hereby files his supplemental memorandum of points and authorities in support of his position that the First Amendment, Article 16, restrictions in this case styled as pretrial stay-away orders for individuals wherever they may be found or travel must be vacated on constitutional and overbreadth grounds. Mr. Kearney respectfully requests Superior Court review and vacate the release determination of the Stoughton District Court. Mr. Kearney further asserts in the alternative that as a simple matter of statutory discretion by the Superior Court, the orders may be vacated as inappropriate in the circumstances and unnecessary. In addition to the points in his initial petition, Mr. Kearney states as follows. Number one, the court properly pointed out in last week's initial hearing, the quality of the Commonwealth's case here, the weakness and lack of viability of the case is relevant to whether the terms of release are reasonable and appropriate. Why was it before the court? Why was it before the court? The quality of the case. I don't know what. I don't know why it was. Why was it before the court? Why would the court? Did the court find that there was weakness and lack of viability of the case? Or am I misreading this? Or is he misrepresenting it? Because the quality of the Commonwealth's case would be relevant to whether the terms of release are reasonable and appropriate. Yes. But if the court's already found that the Commonwealth's case is weak and lacks viability, then one might wonder what evidence has been presented in this early stage, because I didn't see any weakness in this, what is referred to as a complaint and may or may not be. So I don't know. No one's saying anything. So number two, the case is without probable cause and violative of Mr. Kearney's due process rights and fair notice of what constitutes criminal behavior. I don't know. I don't think so. Yeah, I would think that if the court thought it was, if the court thought it lacked probable cause, then yes, the court would dismiss it, because that's what courts do. I'm assuming you took something out of context. So now he's attacking the statute, I guess. Is he saying the statute's overbroad? I don't know that the statute's overbroad. The statute's been reviewed before. I've read several cases on the statute. For example, there's Tebow. Tebow is on it, and yeah, I don't see that it's been. This was Tebow's from 2020. So, I don't know. According to collateral orders infringing on fundamental rights only further exacerbate the constitutional wrongs in the case and should be vacated. That's dookie so far. I don't know why the fuck he's wasted the time on this. I guess he got so, if the facts are in your favor, you argue the facts. If the law is in your favor, argue the law. If the facts and the law aren't in your favor, you pound the table and shout like hell. The defense contends that this case is nothing more than a conspiracy to violate Mr. Kearney's civil rights, stifles free speech, his right to free speech, and crushes ability to petition the government for redress. How is this crushing his ability to petition the government for redress? He's literally just filed. This is literally a fucking petition that he has filed to the government seeking redress. How the fuck is it? How the fuck has this at all crushed his ability to petition the government for redress? Well, he should really file a motion to attack the statute on overbreadth grounds then, because I don't know. The case was brought as a pretext to immediately shut down Mr. Kearney's investigative reporting by the very targets of that reporting. The government is using stay-away orders to keep him out of court and government meetings and locations on the whim of the 8 individuals. Is it actually keeping him out of court? Interesting. The false charges also ostensibly support the unlawful confiscation of his phones and computers for an attempted wholesale phishing expedition to learn his sources and acquire his yet undisclosed leads in related and unrelated matters. The government has agreed to cease further intrusion in Mr. Kearney's devices, pending litigation on the appointment of a taint team to shield Mr. Kearney's sources and materials. A taint team just means that there's like another group of people that are going to go through it first before the investigators go through it to determine what is or isn't relevant to the actual investigation. If they have any issues, normally they could bring it in front of a judge, so that the judge would, because usually each side appoints people to it. So if it's not unlawful confiscation of his phones, if they had a warrant, right? They had a warrant, right? Which I mean, if they had a fucking warrant, that means it's not unlawful. It's not unlawful. Like, I don't fucking understand. How the fuck is it unlawful? No citations to authority for that. Now we finally get to something with citations to authority. The charges brought implicate long-standing investigative journalistic behavior never before criminalized in the Commonwealth. A criminal statute must give fair warning of the conduct it makes a crime. I don't know if like calling for a call flood or calling for people to brigade another person's work's social media is like investigative journalistic behavior. And I don't know. I don't see. You have to. Yeah, this is just stating it doesn't give fair warning of the conduct that makes a crime. To me, doesn't really. I mean, it's not a really good argument. You're not really laying out why. Why doesn't it? Like, which part of it is vague? Which part of it needs further definition? Right. The underlying principle is that no man shall be held criminally responsible for conduct he could not reasonably understand to be prescribed. I think this might be taken a little bit out of context. It's not whether an individual person could not reasonably understand it. I don't think. I think it's rather like an ordinary person would be able to understand what the fuck it means. Understand that what they're doing is fucking not legal. Ignorance of the law is no. But again, he doesn't say what in here. He doesn't state what it is specifically that is unclear. The court seems to think it's clear. The whoever issued the arrest warrant seemed to think it was clear. In Tebow, the Court of Appeals seemed to think it was fucking clear. There's elements. The elements are defined. Like I don't understand what's not clear, right? I don't understand. The Supreme Court has compared fair warning standard to the clearly established standard applied in civil cases. To be clearly established, existing precedent must have placed a statutory or constitutional question beyond debate. I don't know. Seems pretty fucking clear. And I don't know. The fair notice requirement cannot be satisfied by post-conduct judicial interpretation of the statutes at issue. If the 14th Amendment is violated when a person is required to speculate as to the meaning of penal statutes or guess at the statute's meaning and differ as to its application, the violation is that much greater when, because the uncertainty as to the statute's meaning is itself not revealed until the court's decision, the person is not even afforded an opportunity to engage in such speculation before committing the act in question. Well, well, fuck me here. Let's take us a little peeky poo here. So look at all these cases they've cited: Commonwealth versus Gordon, Commonwealth versus Shiner, Commonwealth versus Drumgoole, Commonwealth versus Cassiano, Commonwealth versus Potter, Commonwealth versus King, Commonwealth versus Lester, Commonwealth versus Kathy C, Commonwealth versus Pagels, Commonwealth versus Robinson, Commonwealth versus Hamilton. I don't know. It seems like this has been pretty fucking litigated to me. 2005, 1998, 2000, 1995. So maybe if this was back in 1990 motherfucking 5, maybe if it was back in 1990 motherfucking 5, you might have a bit of an issue. But it seems like this statute has been around for a fair few minutes. A fair few minutes. I'm a guess that it's pretty well defined. Again, we're talking about fair notice. So here, Mr. Kearney's, so this is an as applied, I guess. I don't know. His alleged speech criticizing a murder investigation. That wasn't in the complaint. Alleging a cover-up. That's not one of the issues. Contacting, speaking to, and accusing persons affiliated with government officials as a true culprits. Now, if it was just contacting and speaking to, sure. But what about the call flood bit? What about that? What about brigading the social media? What about putting their phone numbers up? What about the statements about you'll never have a fucking normal life again? What about those? I don't know. Is that like, is that really what, like what other journalist has done that, right? What other journalist has done that? I don't see that happening. Now, I saw there was this. So I just quickly perused it. I haven't gone through it entirely, but maybe he's gonna make a case. So he says it's never been used as a basis for witness intimidation. These are normal journalistic tactics. Normal. And he's gonna be able to cite to tons of people who have fucking put out phone numbers and invited their followers to call flood, right? Yeah, Dan Rather does that shit all the time, right? He doesn't do the news anymore, right? These normal journalistic tactics have never been deemed criminal by Massachusetts court. Thus, the case will ultimately fail, and collateral orders keeping him from further First Amendment activity must be vacated by this court. Well, you know what? If instead of trying to get rid of the bail conditions, if you filed a motion to dismiss the case based on the overbreadth of the doctrine or the as applied, unconstitutional as applied, and you get the case dismissed, then you don't have to worry about the bail conditions, right? Right? Why not do that? Probably because he doesn't think it's going to work. Why not do that? In a related context, in Snyder versus Phelps, the Supreme Court held that speech made in a public place on a matter of public concern cannot be the basis of liability for a tort of emotional distress. This isn't a tort. This is witness intimidation, but please continue. Even if the speech is viewed as offensive or outrageous, the First Amendment bulwark extends broadly and supports Mr. Kearney's and every investigative journalist's methods. Except you're trying to apply general standards of the First Amendment to the specific case where there is witness intimidation. And again, witness intimidation affects the most fundamental right, not a fundamental right, the most fundamental right, your right to a fair trial. The most fundamental right. If you can't get a fair trial, nothing else is worth anything. If you can't get a fair trial, nothing else is worth anything. It is the most fundamental right. You're putting up a fundamental right against the most fundamental right. One of them is going to give. Which do you think it's going to be? That's sarcasm, by the way, in case anybody's wondering. The government dismissively characterizes Mr. Kearney as a local blogger. Well, what the fuck do you think he is? He talks about Massachusetts shit. Mr. Kearney is an award-winning investigator. Who the fuck cares? Disparity. I have no. However, this disparity. So I'm going to bring up that there's a disparity in what they're calling him and in what I'm calling him, and then immediately say it has no legal materiality. So why the fuck did you bring it up? Why the fuck did you bring it up? Mr. Kearney has provided the court with a supplemental affidavit filed herewith containing many live links to his protest and reporting. Video of countless times he implores his followers to follow the law or don't attend his gatherings. You know all those times where First Amendment auditors are like, here's the phone number to such and such a place, and I'm telling you, don't call them. Absolutely do not call this number XXX, and tell them about how disappointed you are. Do not do that. You know how many times they've done that? You know, like most people aren't stupid. If the audiences who believe in and who follow those charlatans can understand that those charlatans actually want people to call, then a judge is also going to understand that the actual intent is to get people to call, right? And if the people who believe in those charlatans are smart enough to figure out the actual intent, then a jury comprised of normally intelligent people, 100 IQ plus or minus people, are also going to be able to figure it out. And an exhaustive collection of investigative journalists doing the same investigating, i.e., let's see what, calling people and doxing their phone numbers. The same investigating. It's identical, guys, because it's reporting. So all reporting is reporting. And if I am a member of the press and I put out people's phone numbers and I tell people to call flood them, it's just reporting because I'm a reporter. Of journalists doing the same investigating that the government has suddenly characterized as criminal when applied exclusively to Mr. Kearney. Collectively, his admission and the arguments herein compel the conclusion that this doomed prosecution cannot sustain collateral orders restricting his vile investigation. Yada, yada, yada. All right, let's look at this. Holy Jesus. So this is his supplemental affidavit. I, on oath, do depose and say blah, blah, blah. Judge Peter Krupp asked my attorney at the hearing on October 26th, your view is that a journalist can bring a dozen other cars, honking horns in front of a witness's house and calling out to neighbors to call on their neighbor to do the right thing. I reviewed the footage, and the honking exclusively took place outside of the Canton Police Department, which is located on the busiest road in Canton. The honking came exclusively from motorists who were not involved in the protest itself. Did you ask them? Did you do a poll? How do you know they weren't involved in the protest itself? If the protest involved cars, how do you know which ones were and weren't involved? How do you know? How can you tell definitively that the cars that were honking were not involved in the protest? It's a tad bit windy. At the 2-hour and 20-minute mark, you could hear a big rig driver loudly honk his horn in support of the protesters, which he was not one of. He was just in support of them, right? He wasn't one of them. He was just in support of them. Isn't that a fucking fine line to draw? I don't want to watch all this. But this is a rally. This is a rally. This is a rally. What is the difference between a journalism and rally? What is the difference between journalism and a rally? One, you are creating the news. The other, you're reporting on the news. This is a rally. It literally says in the title, "The Justice for Karen Read and John O'Keefe Rolling Rally." I'm schizophrenic? All right. I guess. I don't know. Really? Maybe. Depending on Massachusetts law, and I don't fucking know it. I will defer to you, Top. I will defer to you. So that's pretty much garbage. That's pretty much garbage. Where are we at? Likewise, there were honks outside of my arraignment in Stoughton, and even during the brief hearing in this courtroom last week. Honking! Honking is protected speech. Honking. Honking is protected speech. I don't even know how to respond to it. Are you enjoying the guinea fowl? Enjoy them. How do you even respond to honking is protected speech? How do you even respond to that? Like, what the fuck kind of idiot says honking is protected speech? At best, honking can be incorporated into protected speech. Sure. Honking could be construed to be speech if you're intending to convey something with it, a communication, theoretically, but honking in and of itself is not protected speech. In and of itself, it's not protected speech. Honking is not in and of itself protected speech. Massachusetts General Law, Chapter 16, Chapter 90, Section 16. No person operating a motor vehicle shall sound a bell, horn, or other device, nor in any manner operate such a motor vehicle so as to make a harsh, objectionable, or unreasonable noise. Sounds like it's not as protected as Turtle Boy would make one want to believe. Honking is protected speech. But the answer to Judge Krupp's question is yes, protests are designed to make people uncomfortable. So now he just admitted, this dumb fuck just admitted he's out there protesting, which is First Amendment activity, sure. And he's also protesting at a witness's house. And what is his intent to do at this witness's house while he's protesting? What is his intent? Huh. A few important examples. There was an incident of less than 10 miles from this courtroom 250 years ago this December where a bunch of protesters threw tea in the harbor in order to protest against tyranny and oppression. Did the tea belong to witnesses? I don't know. It's fucking weird, dude. Like, this motherfucker is like, is comparing what he's doing to the Boston Tea Party? I mean, I guess his hubris is somewhat unrestrained. Martin Luther King Jr.'s organization of the Birmingham campaign focused on illegally disrupting restaurants, churches, libraries, and more with sit-ins intending to overrun the local jails. They marched from Selma to Montgomery, as well as the March on Washington, relied heavily on blocking traffic while marching. Well, couple things of note. None of that happened in Massachusetts. So none of that involved witness intimidation. So, and what the fuck is the point? Martin Luther King Jr. got arrested for some of that shit. People in those marches got arrested for it. I don't even fucking understand. I don't even understand. Good trouble, in quotes. Civil rights icon John Lewis famously said, "No one fucking cares." On the 55th anniversary of the Selma March, he, quote, illegally, end quote, participated in. Never, ever be afraid to make some noise and get in good trouble, necessary trouble. He also spoke of the importance of large groups of people getting together and being loud and peaceful in the streets as a better alternative than watching injustice play in the courtroom. So what he's fucking telling you is that it's more important that he be able to get to these people to protest than it is for him to do journalism. He's talking about protesting. He's not talking about journalism. He's so far off base. He's so fucking far off base. He's saying, I should have access to these people because I'm a journalist. You're interfering with my First Amendment activity as a journalist. Oh, and by the way, I've been protesting them, organizing protests, honking, things like that. Yeah. Oh, journalism too. But mostly this stuff because me and Martin Luther King, we're tight. Me and Martin Luther King, we would have been holding hands at the Boston Tea Party or some shit. He said, quote, "No one fucking cares. This is what we believed in. What we were all about. A mass movement. An irresistible movement of the masses. Not a handful of lawyers in a closed courtroom, but hundreds, thousands of everyday people, disciplined, peaceful people, taking their cause and their beliefs in the streets." There is a fundamental difference in marching against a statute, law, ordinance, constitution, whatever that you think is inappropriate, and marching to intimidate witnesses. There is a distinction between them. You're not allowing the court processes to take place. The court is there to determine the truth or falsity of the testimony of the witnesses. There's going to be a jury there. You're not marching against something unconstitutional. You're marching against the procedures of the court. You're marching against the procedure of the criminal justice system. Aren't we all a little hypocritical from time to time? He said, blah, 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 who cares? In the summer of 2020, we heard nationwide cries of no justice, no peace. What does this have to do with Massachusetts? In response to the murder of George Floyd, what does this have to do? This happened before Derek Chauvin was arrested and charged with killing him. Like myself and my turtle riders, these protesters were speaking out against what they believed was corruption and injustice. And that the most effective way they could petition to the government to address this corruption was through large, disruptive demonstrations in public. But where did they go? Where did they go to intimidate witnesses? Where did they go to intimidate witnesses? Where did they go to intimidate witnesses? And did the Massachusetts statute apply? To the best of my knowledge, George Floyd was not killed or died, whichever way you decide to believe, in Massachusetts. So who the fuck cares? Who the fuck cares? This is inapposite. It doesn't apply. Congressman Alexandria Ocasio-Cortez stated in 2020, well, who the fuck cares? All politicians should die. The whole point of protesting is to make people uncomfortable protesting it. He's talking about protesting. I don't know why we're talking about protesting. I thought this was about his press rights. Activists that take discomfort with the status quo and advocate for concrete policy changes, not witness intimidation, policy changes. Popular support often starts small and grows. To folks who complain protest demands make others uncomfortable, that's the point. Well, see, like, again, protesting to change laws. Protesting to change laws is entirely different than protesting to intimidate a witness. We are a republic made up of a federation of other republics. And you can and should change people's minds about laws, about what should and shouldn't be the law. That's what a protest should be targeted at. Changing laws, not witness intimidation. Congressman Ayanna Pressley, who the fuck cares? Turtle Wires and I were doing exactly what this elected leader, Congresswoman, who the fuck cares? All these loud, disruptive protests have one thing in common. They all led to political change. Well, did what political change? See, the criminal justice system is supposed to be. He's not that smart. The criminal justice system is supposed to be divorced from the political system. You're not supposed to be convicted based on mob rule. You're not supposed to be convicted based on vigilante justice. You're not supposed to be convicted based on politics. There is a prohibition against ex post facto laws. Ex post facto means the thing that you did was legal, and then politically, somebody comes behind politically and makes what you did a crime and then charges you for it. So when you did it, it wasn't a crime, but now it's a crime. That's an ex post facto. And that's like, so you're not, the criminal justice system is not supposed to bend to political pressure. So what political outcome did he get? What the terrorists and I are doing is no different from what any of these groups did yet. Which one of them was marching to intimidate witnesses? Show me the one that was marching to intimidate a witness. In fact, it is the most American thing you could possibly do: come together in large groups to peacefully protest and demand the government stop repressing. You were protesting outside of a witness's house. In response to this exercise of freedom, the very same oppressive government agencies my supporters and I were protesting against sent men with guns to an award-winning journalist's home, criminalizing his nonviolent activism, raided his house, and took his personal property tools of trade, violated his right to privacy, and compromised thousands of confidential sources. They did that with a warrant. And what do the victims of the alleged victims, I should say, of the witness intimidation, do they think that the government was oppressive in doing this, or do they think the government was protecting them by doing this? Which do you think? Put their socks on for a minute. Well, they did this to send a message: stop protesting against government corruption or we will rob you of your freedom. No. They did it to send a very clear message: stop intimidating the fucking witnesses, you asshole. That's what they said. Stop intimidating the fucking witnesses. You could, from my understanding, he is not at all restrained from protesting. He's not at all restrained from protesting anywhere except for within a certain distance of the witnesses. And from contacting the witnesses. He could march down through Boston today, right? Today. Get a little banner out, march through the streets, wave his little banner saying whatever the fuck Karen Reed is guilty or innocent or whatever the fuck his position is on it. I don't really know. Don't care. You can still protest. You can still protest. On October 26th, this court asked. Well, so the monetary losses are an excellent proxy for how much you are disrupting a business, and if that business is tied closely to a person, then yeah, I mean, if you could show monetary losses, that shows how much of an effect this person is having. And if you're a witness and the person is inflicting these monetary losses on you as a means to intimidate you, then yeah, I mean, like, dude, if I'm a witness to a case and you start calling all of my clients and make, whatever, however you convince all my clients to drop me, and all of a sudden I'm destitute, that's very fucking intimidating. So yeah, monetary losses are a great proxy to show exactly how effective the intimidation is. On October 26th, this court asked if a journalist could bring a dozen other cars honking horns in reference to a July 22, 2023 rolling rally through the town of Kenton. Although we do not concede that there was any honking of horns by my supporters, even if there was, it would be protected speech. Citation needed. It's easy to protect quiet, non-controversial speech that defends the government, but most important speech in need of protection is speech that's loud, controversial, and critical of the government. That is exactly what my supporters and I attempted to accomplish with the rolling rally. But see, if you fucking end up at the house of a witness and you're doing this targeting the witness, that's where there's a fucking problem. Additionally, I had been publicly stating for weeks prior I'd be organizing this peaceful protest in Canton. At no point did the Canton City Police Chief Helena Rafferty issue any sort of statement that this would be illegal. It was only afterwards that Chief Rafferty and the state police began to launch an investigation and find a way to criminalize protected speech by weaponizing the statutes or the witness intimidation statute. No Canton police were present or called to the scene. Well, normally what happens, we were just talking about prior restraint. If Chief Rafferty said, you can't do this rolling rally, that might be prior restraint. If otherwise it's legal for them to do it, if the police chief says you can't do it, prior restraint. But if you do the rolling rally and you break laws while you're doing the rolling rally, then you get investigated. Like he was literally complaining in the petition that it was prior restraint, and then there's no fucking prior restraint. He's like, but you didn't prior restrain me. Fucking idiot. His argument is literally, you didn't use prior restraint, therefore I shouldn't be prosecuted for the charges I did. After submitting a petition claiming the government committed prior restraint, he's saying that the government did not commit prior restraint, but fucking should have. I don't know how to deal with that. I don't know how to deal with that. I don't know how to deal with that. I'm not hiding what my supporters and I did that day. As a matter of fact, we filmed the entire protest for my YouTube channel. As you can see from the highlights of the rolling rally, it was attended by women, small children, elderly, people of all backgrounds. Here are images and videos of what the government wants you to believe is witness intimidation. But even just posting it on your YouTube channel might also be witness intimidation. We protested out, and I haven't watched it, but if he said we were protesting out in front of, I don't know, so-and-so's house, and that so-and-so is a witness, now you've identified their house on your YouTube channel. You've brought a crowd of people. I don't care if it's I mean, like, the riots during the summer of, what was that, 2020, where they burned down large sections of many cities. Those were attended by women, small children, elderly, and people of all backgrounds. And places still burned down, and people were still hurt, injured, murdered, etc. Just because there are women, small children, and elderly there, and people of all backgrounds, doesn't mean that it's not intimidating. A crowd of people is a fucking crowd of people. There's an inverse, there's a direct relationship between the IQ of the stupidest person in a mob and the IQ of the average IQ of the mob. A mob is about as smart as the dumbest person in it. And you can see it happen all the time. Like, one person will run up and start like breaking something, and then next thing you know, 20 people are doing it, and then everybody's doing it, right? Fucking stupid. The purpose of all peaceful protesting is to attract the attention of the media. I thought you were the media, motherfucker. You were the media. I'm an award-winning journalist, but I need to go out here and I need to fucking protest to get the attention of media. I'm an award-winning journalist, and I need to go out here and protest to attract the attention of the media. So the message can be amplified, and the government is forced to address the corruption. What corruption? The large but mostly peaceful protests, J5. There were protests in Sacramento. There were protests in Seattle, Washington, Portland, Oregon, Michigan. Wasn't that where George Floyd was died or was killed? There were lots of protests around 2020, the summer of 2020. There was a lot of protests. The morning rally was attended by Boston Magazine reporter Gretchen Voss, as well as local news station who broadcast highlights of the peaceful family event. To date, I have been the only person arrested for being there. You organized it, but for you, right? And you have all the other issues that were complained about in here. So it's not like a single issue. It's all of these things compounding to show your intentions. Because remember, they have to prove that this, and so you have to have all four of these things. You have to show that then it did so with the intent to impede or interfere with the investigation or proceeding, which they might not be able to do with all the other people, probably won't be able to do with all the other people, or in reckless disregard of the impact his conduct would have in impeding or interfering with that investigation or proceeding. They'd have to basically know that what they were doing was going to do it and do it anyway. And think about this. Think about this. Every day, thousands of people speed. Hundreds of thousands, maybe even millions of people speed. And let's say on one day, you are the only person arrested, or not arrested, cited for speeding down a particular section of road. And as you're sitting there pulled over, and all these other cars are whizzing by, you think to yourself, but wait, they're speeding too. So this is wrong that I'm giving a ticket for speeding when all these other people are speeding past me right now while I'm getting this ticket. The cop should stop giving me this ticket and go and give them tickets. It doesn't work that way, does it? It doesn't work that way. Reality exists. Prior to the peaceful protest on July 22, I announced, as I have hundreds of times prior, that I wanted the protest to be peaceful and nonviolent. I specifically ordered people not to attend if they couldn't control their tempers. I ordered people, i.e., I control them. So whatever they do is what I ordered them to do, because you can only order people you have control over. This guy is fucking retarded. They're my Turtle Boy riders. I ordered them. They're my Turtle Boy riders. I specifically ordered them. They're my Turtle Boy riders. I ordered them. I'm responsible for everything that happened because they're my Turtle Boys and I ordered them. You fucking moron. You fucking moron. I'm proud of what we did on July 20th. Oh my God. I'm so proud. I saw the Chara live stream of the event posted on my YouTube channel. I am confident it was legal, protected speech. At the 4130 mark, you see me arrive the home of the victim. Oh my God. Oh my fucking God. You can see me arrive at her home, specifically point out that she has no trespassing sign. So we wouldn't be trespassing by going on her property. So this is a protest, and we're gonna fucking take this protest onto her private motherfucking property. Oh my God, this guy is so fucking stupid. Holy Jesus. Oh, oh my God. Oh, I point out that she has. Oh, I'm sorry, I misread it. She has no trespassing signs. Not she has no she has no so we not be so. So if she didn't have them, if she fucking didn't have them, then it would have been okay, right? Then it would have been okay, right? Weeks earlier, those signs were big not there when I went to her home to question her about her involvement in the murder of a Boston police officer. So I rang her doorbell and stood in front of her door, which was wide open. Okay. So we're identifying the victim's house here, guys. We're identifying the victim's house. Isn't that nice? That's nice. We're just gonna go ahead and identify a victim's house. You know, why not? I give you credit when credit's due. You have nice tits. So he shows essentially where a victim lives. Yes, he does. Great. Congratulations. And he went to her house not once, but twice. He's now firmly established that he's been to her house not once, but twice. It's a pattern, folks. He has established for the court, for the prosecution, that it's a pattern. Good job. Good job, Turtle Boy. It's a pattern. It's a pattern. The only intimidation violence on the day of the rolling rally came from alleged victims in this case and their supporters. Elizabeth Proctor, has a stateway order on me here, posted a picture on Facebook of local activist Angela Chan O'Donnell, who, like me, has been a vocal critic of the government and attended the rally with a 3-year-old son. She did this in order to attempt to scare Miss O'Donnell into ever attending another protest. No one set foot on her property during the protest. The children had set up a lemonade stand across the street, knowing the rally would be going to Wentworth Road. Is Miss Chan O'Donnell a witness? Oh, she's not. Oh my God. What? You mean the law applies differently to different people? A prohibition on witness intimidation only applies to witnesses? Fucking dumb. Fucking dumb. And what is it? Like, what is this? But she did it first. Like, what's your point? She was mean to someone else. What's your point? What's your point? What the fuck is your point? Someone showed up at her house to fucking protest her. Someone showed up at her house to protest her and she was mean to that person? Holy fucking shit. If you show up to my house to protest, you might get a little bit of mean John. I might be a little mean with you. And I'm not a witness. Additionally, the only illegal action was when a woman named Diana White, who was a close friend of the same government officials, threw an egg at a 5-year-old boy who was with his mother at the protest. Again, someone else did something bad, therefore don't prosecute me. Someone else did something bad, therefore don't prosecute me. The legal genius of Turtle Boy. There's nothing unique, novel, or illegal about my investigative journalist except the whole fucking doxing their phone number, having people brigade their places of work. Except for that, leading protests out in front of people's houses. That's pretty unique and novel. And since they're witnesses, it's illegal too. Isn't that right, buddy? Yeah, isn't that right? My lovely wife let the dog out, and he's shivering between my legs. I gotta let him back in. So-called ambush journalism, which is completely separate and distinct from leading a fucking protest to someone's house, in which journalists surprise people they are investigating by confronting them on camera in order to ask them questions. Sure, has been commonly used, highly effective tactic for reporters for decades. There are too many examples to count, but here are several. Now, what we're going to look at, number one, is were these people charged? Number two, were they charged under the witness intimidation statute? Number three, were they charged in Massachusetts under the witness intimidation statute? And so basically what we're looking for is people who've conducted ambush journalism to witnesses in Massachusetts. Let's just stop there. Witnesses in Massachusetts, right? Witnesses in Massachusetts. That's what we're looking for. Witnesses in Massachusetts. Someone's trying really hard to change the subject in the comment section, but sorry, we're sticking to the topic at hand here. We're sticking to this bullshittery. Compilation of Boston reporter Mike Boudreaux confronting subjects of his investigation, including a judge in public. A judge, wow. Did he try to change the? Or did he try to intimidate or harass the judge, or did he just ask the judge questions in public? Was there an ongoing case he was trying to change that he had stated that the judge was doing wrong on, that he was confident the judge was prosecuting the wrong person? Let's watch it. I don't know if you guys can hear it. If you can hear it, let me know. If you can't, let me know. All right, no sound. All right. Try this again.
Believe it or not, a night in the woods hasn't turned the Millers off from hiking.
From our very first newscast, he's reported some of the most talked about stories.
So this is a Judge Rotenberg video, apparently. You still can't hear it? So this is a Judge Rotenberg video.
Dramatic video of New York teenager Andre McCollins restrained.
New York teenager.
Face down, a helmet on his head, screaming for help. The Judge Rotenberg Center calls it treatment.
The Judge Rotenberg Center calls it treatment. So this is the Judge Rotenberg Center. Judge, spelling helps. So the founder was somebody named Matthew Israel. Has nothing to do with the judge. Okay, well. So that was it. That's where he confronted the judge. That's where he confronted the judge. All right. So the judge in this particular case was a defendant. He was trying to interview a defendant. Inapposite doesn't apply. Congratulations. There was a guy who did a thing. I don't want to do. Oh, you could shit. I was on the wrong screen. Doing this again. All right, so let's see if you could hear it now. Whoop, shit.
Believe it or not, a night in the woods hasn't turned the Millers off from hiking.
From our very first newscast, he's reported some of the most talked about stories. He kept his patience and his professionalism, no matter how long it took him to get answers.
Hi, excuse me, Judge Curtin. Mike Boyette with Fox 25. We wanted to talk to you about the Logan incident. Can you tell us why you took the watch? Ma'am, if you were trying to return it, why'd you walk away with it? Can you just answer a few questions? We're just trying to understand your side of the story, ma'am.
And as the Fox Undercover investigative reporter, he broke.
So the judge in this particular case may or may not have stolen something. So the judge would be a defendant, not a witness. I don't. There's a difference here. Like he didn't put up her phone number. He didn't organize a rally in front of her house. It was one man with a camera, maybe another guy following behind him or one guy with the camera, another guy with a microphone. I mean, there's a huge difference. Yes. Interview, not intimidate. There is a difference. People can understand the difference between those two things. Rachel Rollins threatens a reporter with arrest outside her house after being confronted about the road rage incident. So this is him, I guess. Okay. Again, there's different. Oh shit, you can't see this. There's a difference between asking questions and organizing protests. What was she being asked questions about? Hold on a second. Before we go there. So, investigator harass. So, attorney. See, I don't see what they're doing to that misleads, intimidates, or harasses by going up and asking one question. Or by going up and asking some questions. Let's see. Rachel Rollins. Well, fuck it. We'll listen to it. We'll see what they have to say. Let's see if this is witness intimidation. Let's see. I'm going to go ahead and watch this. Sure we're on the right page. Everybody's fighting in the comment section. They're not actually watching what I'm doing, so I don't know if it really matters. All right.
People are debating whether it's okay or not to show up at a private residence of a politician. In this video, you're going to see U.S. Attorney for Massachusetts, D.A. Rollins. Notice how quickly she turns this into a race thing.
Oh God, my kids are inside. Can we take for 1 second, Ms. Rollins? You're in front of my house with my children? We literally just pulled up here. Yeah, but how do you know where I live? Oh, it's public record, ma'am. Right, okay. That's unbelievable. We're not stopping you at all. Yeah, but my kids are inside. Oh, we never even knocked the door. We just walked in here trying to figure out where we were going, and someone said we saw you here. So. Yeah, okay. Thanks. Yeah, no, I'm going to please make sure that you're in front of my house with my children inside. And you're going to put this on here. Yeah, so as a black woman, in this moment, in this country, you're going to put my house on the screen? No, ma'am. We're just here approaching you to ask you a question. Get away from my family. Speak to me at my job. If I get hurt or harmed because of this, you are on the record for that. Or my kids are killed. Who do you think you are? This is private property. Get out of here. And you know what I'll do? I'll call the police on you and make an allegation, and we'll see how that works with you. So the rantings of a white woman getting that you hear and scare my children, get off of our private property. And I swear to God, I'm dead serious. I will find your name. You can ask me somewhere else. Do not have a camera in front of my house. I can give you my name. Get her out of here. This is about I will have you arrested. I swear to God.
Okay.
My children are going to be hurt.
We're just here to ask a question. You don't even know where you live.
Get away from my house. I'm serious.
Please, please.
Okay, we're going to step away.
Thank you.
Okay.
Please, please.
Okay, we're going to.
Are going to be hurt.
We're just here to ask a question. You don't even know where you live.
Get away from my house. I'm serious.
Please, please.
Okay, we're going to step away.
Thank you.
Okay.
Out of respect.
Absolutely.
Okay. I don't know what the point of that was. Was that in relationship to a particular case? I don't think so. And there is a difference between showing up at a politician's house. If she's the DA, that's an elected position. It has to be in connection. All right, so let's go back to the statute. It has to be in connection with has to impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation. It has to proceed with it has to interfere with a criminal investigation or criminal proceeding, right? So does this show the 7 said was what they were doing interfering with a criminal investigation or criminal proceeding? Let's go back to this one. So there has to be a possible criminal violation that would trigger a criminal investigation or proceeding. The victim would like that to be a witness or prosecutor in that investigation or proceeding, or was a family member of such. The defendant had to engage in intimidating behavior. Just in it by itself, asking questions would not be intimidating for a normal person. And the defendant would have to do so with the intent to impede or interfere, or in reckless disregard with the impact the conduct would have in impeding or interfering. So you have to show that there is an intent to interfere, or they knew it would interfere, but they did it anyway, right? So you're missing a lot of things there that would normally be applicable, but we'll continue on. Reporters, protesters outside of Derek Chauvin's home. That's not in Massachusetts. Reporters protest out of Supreme Court Justice's home. That's not in Massachusetts. Alex Stein confronts Brittany Greer at an airport. Again, is Brittany Greer a witness to something? I don't even know who Brittany Greer is. Brittany Griner, a WNBA player. Who the fuck cares? Inside Edition confronts fare evaders. Oh my. Reporter Bill Malugan confronts real estate imposter scamming people out of security deposits. Again, are these witnesses? Fare evaders, are they witnesses or are they actual, would they technically be defendants? A real estate imposter scamming people, would they be witnesses? Is he intending to disrupt a criminal proceeding? He confronts a man selling sick puppies. Oh no. Philadelphia. Well, Philadelphia isn't in Massachusetts. Reporters knocking on doors. Woo! Ilhan Omar. She's a politician. Congratulations. Las Vegas. Matthew Boynton. Not yet. Reporter confronts Officer Matthew Boynton. Georgia. Congratulations. So somebody from Georgia. O'Keefe confronts the subject of his investigation. Is that person a witness? Don't know. Don't care. Probably not, because again, it has to be done with the intent or reckless disregard that it will disrupt the criminal proceeding. Reporter confronts a woman in Rhode Island. Woo! Rhode Island is not Massachusetts. Senator Jeff Flake, that's a politician, not a witness. I've used these tactics as part of my investigations. What? Holding fucking rallies? In September of 2020, I began loud, disruptive protests outside of a nonprofit owned by Monica Cannon Grant. As a result of my investigation, a defendant was investigated. A defendant, again, not a witness. I was shocked and surprised, blah, blah, blah. My attorney explained to me. Well, if your attorney explained it to you, then fucking awesome, right? Hold on a second. I need to do the thing again. Hold on. I need to do share screen. I need to do entire screen share. All right. So we're going to do that. This is the prosecutions. 9 separate criminal complaints. Big into blog, yada, yada. He's visited the homes of the witnesses, videotaped the interior of witnesses' homes without their permission, led motor vehicle caravans past the homes of witnesses, showed up and harassed witnesses at sporting events in which the children of the witnesses were participating, harassed witnesses at their places of business, attempted to cause witnesses financial harm, and followed witnesses while yelling at them through bullhorns. So, what is the fundamental difference between showing up once to confront somebody and ask questions and another time just to show up and bully them? What's the difference? Been through this? No, that's a lie. You're lying, or misrepresenting, or you didn't understand it. That's a lie. You're lying. Misrepresent. We did it already, but I will do it again for you, Kate, to show you that you're either lying or misrepresenting, or you weren't smart enough to figure out what he was saying. And you're not acting in good faith. So this is the video. Hold on a second. Gotta do it this way. Present, share screen. That one. Okay. So you can hear it. All right. You ready?
Let's start off by pulling up the statute, shall we? Or pulling up not the statute, the ruling, the entire thing. And by the way, it's a 22-page document. They had 3 missing pages at the end.
They had, past tense, they had 3 missing pages at the end.
3 missing pages. Where did they go? Like, we had to call the court to get, and there was the 3 pages that were kind of like most.
We had to call the court to get them. We had to call the court to get them. So his was missing. Oh, now you understand what he was saying. Now, hey, folks, attention, please. Now she understands what he was saying. Now she understands. So why were you fucking painting him in a false light? Like, I get it. You don't like him. I get it. He's an asshole. But, like, you don't have to paint him in a false light. Let the shit that he does wrong paint him bad. Why are you a cunt, Bex? That's the question that I want to know, is why are you a cunt? That's the question. All right. And, this. Why? So you know what he's thinking, right? You can read his mind. That's what you're telling me? Why would he say that? Like, he literally has all 22 pages there. Why would he say that? Why would he say I had to call the court to get him? And is it outside of the realm of possibility that the copy that he got was missing 3 pages? They got stuck in the copy machine or whatever. Maybe the copy that he got from his attorney went to make copies of them, and the last 4 pages all went through together. So 3 of them were behind the the fourth from last, and so he only got 3. Like, why does it have to be something incredibly nefarious all the time? Why can't it just be something normal that happens to normal people? Have you ever copied something and had pages missing because like several pages went through at once? Has that ever happened to you? I mean, you got great titties, but it only gets you so far. The Commonwealth contends the First Amendment to the United States is not a license to violate state or federal law. It does not confer any special dispensation to journalists, so-called they should violate criminal statutes. The actions for which the defendant is charged are not protected speech in neither the First Amendment to the United States Constitution nor Article 16 of the Massachusetts Declaration give the defendant the right to break the law. No, Bex, because you started off with the assumption. Implied in your statement was that I was hostile. That was implied in your statement. So what I did is I used this exact same technique on you. I implied in the statement, I begged the question, I begged the argument that you were a cunt, just like you begged the argument that I was hostile. So it's not because you asked a question, it's because you implied in the question something that wasn't necessarily true. That's what you want to think. But see, if there's two alternating positions, if there's two alternate positions, the correct one is what is the steelman argument that you can make? What is the not shitty argument you can make, right? Well, I don't fucking care what you think about my tone of voice, Bex. I really don't. You could think whatever you want, but if you tell me instead of, hey, John, are you being hostile? Is one thing. You're saying, why are you being hostile? Is another. You understand the difference? Like, when did you stop beating your wife? You see what I'm saying? You're acting like a cunt. So, if you don't want me to treat you like one, don't act like one. It's easy. I'm easy. But again, I have received documents as an attorney. I have received documents missing pages. I have received documents multiple times missing pages, and I've had to call to find out. Yeah, normally not from the court, but I've had to call for missing pages before. It's not uncommon, and it's like, what does he win? He's literally going to go through all 22 pages. So, like, what is he gaining? Hey, there was a fuck up. It was a stupid fuck up, and I had to do it. Oh, okay. Sorry, you had to call the court. It's not that big of a deal. You're trying to make it a big deal because your assumption is that he always lies and he always does this and he always does that, and therefore I'm going to look at every fucking thing he does through that lens. Just like he does the same thing to you. He does the exact same thing to you. Yeah, and he does the exact same thing to you. His unfavorable perception of you colors everything you do, even when you're trying to be the better person. And I'm going to assume, for the sake of argument, that when you've told me in the past you're trying to be the better person that you were, he did not understand it. He wouldn't do it. Blah blah blah. This and that. And so you guys, neither one of you is a good person, at least not as far as the other person is concerned. And I would love it for once if one of you would man up and not be a complete cunt to the other. I doubt you've ever been intimidated in your life. All right. It is well settled. It's clear that freedom of speech and freedom of the press, which are protected by the First and 14th Amendment against infringement by Congress in the states, are among the most fundamental rights of First Amendment protection. However, has not been approved by courts to be used as a shield to protect persons where speech has been used as an integral part of criminal conduct. Specifically, the constitutional guarantees of free speech and free press will protect advocacy for force of law or criminal violation, except where such advocacy is directed to inciting or producing imminent lawless action and or is likely to incite or produce such action. Accordingly, the state may forbid or prescribe advocacy where such speech is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Specifically, the police power of the state may lawfully punish words which by their very utterance inflict injury or tend to incite an immediate breach of peace. The test of the constitutionality of any statute which in any way criminalizes conduct which contains speech as a component is whether the protection of speech in such instances is clearly outweighed by the social interests in order and morality. So he's arguing right now the state is ignoring the argument about whether or not the bail conditions should be relaxed, and we're going right to whether or not the statute is unconstitutional. So I'm not sure why the state's doing that. It was half-assedly raised, but that's not the pending petition before the court. The pending petition before the court is to change the orders that are associated with the bail conditions, not to find that the statute is unconstitutional. I know he added that shit in his supplemental briefing, but it's not properly before the court, or at least I don't believe it is. I believe the only issue currently is whether or not the orders, the protection orders that are associated with the bail conditions are proper. Massachusetts enacted the law to protect the sanctity of the judicial system and guarantee that any witness or potential witness may testify in the courts of the Commonwealth without fear of harassment, intimidation, or bodily harm to either them or their families. Under the statute, an action need not be overtly threatening to fall within the meaning of intimidation. Neither does the statute require the intimidation actions be successful in causing fear. As an example, in the Cassiano case, the defendant was convicted of witness intimidation under the statute. We saw an undercover officer in the courthouse corridor, took out a cell phone, and pointed to the officer as if he were taking his picture. In that case, there was no evidence that any picture was actually taken, nor was there any evidence the officer actually felt intimidation. Interesting. Let's look at Commonwealth versus Cassiano. Copy. That is muy interesante. Interesting. Interesting. That is interesting. That's a hard case. That's fucking Indigo. That's gonna be a hard case for the defense to overcome. That's a tough one. That's gonna be a tough one. In that case, there's no evidence that any pictures actually taken, nor is there any evidence the officer actually felt intimidation. In the age of so what are the requirements again? The requirements again are specifically that a possible crime occurred that would trigger a criminal investigation or proceeding, that the victim would likely be a witness or potential witness or an attorney in that proceeding or a judge in that proceeding or a investigator for that proceeding. The defendant engaged in intimidating behavior as defined in the statute towards that victim and did so with intent, not with the actual success at, the intent to impede or reckless disregard his conduct would have in impeding or interfering. So that makes a lot of sense. That it wouldn't require that the officer felt intimidation or that there was actually a picture taken. And the guinea fowl are like literally like feet away from me. It's going to get loud. Ugh. going to get loud, boys. In the age of social media, where the ease in which unmediated content may be widely disseminated has greatly increased the potential for sparking criminal disorder. Professor Larissa Lidsky, yada 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 yada. Who cares? You social media, yada yada. Don't care. One of the most insidious forms. Oh, Jesus Christ. I'm going to take a short break. I chased them off and they followed me back. Oh, well, all right. So one of the most insidious forms of intimidation prevalent on the internet today is the practice of doxing. It's revealing identifying information about someone online, such as their real name, home address, workplace, phone, financial, and other personal information. The information is then circulated to the public without the victim's permission. One of the most grievous examples of doxing occurred in spring of 2022 when an unknown employee of the Supreme Court leaked the draft opinion of Dobbs, which indicated that 6 justices had voted to overturn Roe v. Wade. As the opinion was expected to be released at the end of the court's term sometime in late June and could potentially be changed prior to its release, activist groups undertook a campaign to attempt to intimidate the justice into changing their mind. On TikTok, a social media platform, activists dox personal information about 6 justices who were revealed to have voted to overturn Roe, making public the justices' physical addresses, IP addresses, and credit card information, including CVV and expiration date. Soon afterward, and with this information, massive protests were staged directly outside the justices' homes in an attempt to make them change their decision. On June 8, 2022, Nick Roski traveled to the home of Brett Kavanaugh, an Associate Justice to the United States Supreme Court, with plans to break into Kavanaugh's home, kill him, and then commit suicide. After arriving at Kavanaugh's residence, Roski told police he was frustrated with the leaked Roe v. Wade decision. The sole purpose and intent for doxing is to incite others to commit harassing, intimidating, and illegal acts. Accordingly, is not considered protected speech in any regard. Citation fucking needed. Well, gosh. Don't let the door hit you on the way out, I guess. Kate has big tits. Unless your tits are as big as hers, you probably shouldn't make me choose. Citation needed. So doxing is bad, okay. And then no citation to anything. Just doxing is bad, okay. And then, therefore, I'm just going to assert it's not protected speech. Here he dox people, yada, yada, and no real law. Congratulations. The conditions of bail set by the district court are not overbroad. Permits Massachusetts General Law 276, Section 58 specifically permits a judge or clerk or magistrate to set conditions of bail to ensure the protection of witnesses or victims to a crime. The pertinent portion of the statute states if the justice or clerk or assistant clerk of the district court, the bail commissioner or master in chancery determines it to be necessary, the defendant may be ordered to abide by specified restrictions on personal associations or conduct, including but not limited to avoiding all contact with an alleged victim of the crime and any potential witnesses or witnesses who may testify according to defense as a condition of release.
Mr. Caruso is, well, he's not like the kids over at the Welsh News Network. He's not a,
I told no. I told you I wanted to vacuum and dust this room. No. Get out.
hang on one second. Kids over at the Welsh News Network. He's not a,
I told no. I told you I wanted to vacuum and dust this room. No. Get out.
hang on one second.
All right. Hopefully that'll keep us silent for a little bit. Hopefully. All right. I need to hear. I hear him coming back. All right. So in the case of Barr, the district court followed accepted practice to protect those witnesses who have been harassed by the defendant. These orders, which mandate no contact or institute keep-away distances, are similar to those commonly issued daily in Massachusetts criminal case, as well as in cases of domestic violence under General Law, Chapter 209A, and domestic relations cases. Here, the court mandated that the defendant not contact any of the witnesses or their families or go to their homes or places of businesses. Seems pretty simple. I don't have a feud. I have a video of Coded that I just find incredibly funny. It's just a funny video. I find it hilarious. Is there a problem with me finding humor in something? I don't go to his videos. I don't go to his channel. I don't watch his stuff. I have a video though, and it's a very funny video. I'm probably a bad person. You're probably a bad person. So apparently all the court mandated the defendant not contact any of the witnesses or the families or go to their homes or places of business. I mean, if he can't figure out not to go to their homes or places of business, I don't see how he could function in society. He found their homes, he found their places of business. So he should know exactly where he can't go. I mean, he made it sound like he didn't even know where he could go, right? I don't remember exactly where it was, but he was talking about like in general venues, like it was broad. He can't go to venues. He didn't know where he could go. He must gain access to courthouses, right? If this is correct, the court mandate was he couldn't contact any of the witnesses or the families or go to their homes or places of business. There's nothing in here about him not being able to go to court. Contrary to the defendant's sworn affidavit, the court placed no restrictions on him in reporting news about the Karen Read case, nor has he been prohibited from following investigative leads and reporting on those leads. Moreover, the court specifically noted the defendant was not prohibited from attending court sessions if witnesses were present. Wow. The court specifically noted that Turtle Boy was not prohibited from attending court sessions if witnesses were present. That's fucking crazy. That's fucking crazy. The defendant's bail conditions were only to prevent him from contacting and or harassing any witness in the case. Further, contrary to the defendant's affidavit, he is not barred from going to the Norfolk District Attorney's Office for any legitimate purpose. I don't know what that means. As long as he has no contact with the state police detective who is a witness in the Karen Reed case. All right. So he can go there. He just can't contact the state police detective who's a witness in the Karen Reed case. Not a big deal. Additionally, he is not barred from going anywhere in downtown Canton. And it wasn't that he called me an alcoholic. The whole fucking rant was just weird. Like the dude made every stream about me. Every stream was about me. And then all of a sudden there's this weird thing about me being, yeah. But then like the fish tanks, it was just fucking weird. And at that point I was like, man, I can't hang around this guy anymore. I can't listen to him. He's just a fucking weirdo. I'm pretty sure there is zero substance to that to what Coded says. Or Coded thinks a lot of stupid shit. He's probably quivering over in Ireland because he flew across an entire fucking ocean to fight Aiden, all like 5'2" of Aiden, and then he fucking like pussied out. He flew across an ocean to get in a fight with a tiny little masshole, and he fucking pussied out. I'm very pretty. I know you had a typo there. I'm very pretty. I'm incredibly pretty. Well, again, Dakota says a lot of shit. I love Boomer. Yep, I am very pretty. Captain Pretty. You guys are mistyping all over the place. Additionally, he's not barred from going anywhere in, quote, downtown Canton, end quote, with the exception of the pizza shop owned by witness Albert, as it is the witness's place of business. He has not been prevented from going to Canton Town Hall for any lawful purpose as long as he does not directly confront witness Albert, who is a town selectman. The stay-away order issued to protect witness Albert was issued due to the fact that the defendant had a history of obstructing town business at select board meetings by harassing witness Albert about the Karen Reed case. Although the defendant asserts he is not intimidated or threatened any of the witnesses have complained of threats and intimidation by him to the point where the Stoughton District Court has issued multiple criminal complaints against the defendant. The conditions of bail set by the district court are not overbroad as they only restrict the defendant from contact with witnesses who are the identified victims of the defendant's harassment. Boomer is a very cool dude. You gotta clear that one by my wife. I did. I've had multiple beers online. Moreover, they restrict him only from inciting others to harass those witnesses or their families at their homes, places of work, or their children's schools. Protection of victims and witnesses is a key provision of the Massachusetts bail law, and its aim is to ensure the witnesses will feel free to report crimes and testify in court. Here, because of the intimidation was done under the guise of, quote, reporting, the court had to issue those orders necessary to prevent further harassment or abuse. As such, those orders were tailored specifically to the defendant's case and are not overbroad. Sounds it. All right, so it sounds like a there is an IPA that I like. I normally don't like IPAs, but there's one that I like. That's kind of a citrusy taste to it. I forget the name of it, but it fucks me up because it's like 9.5% alcohol. I have to have it after food. If I have it before food, I'm just fucked. And if I have it after food, I'm still pretty fucked at the end of it. Boomer's a good dude. Boomer is a good dude. All right, so that's that. And then I think finally we have the memorandum of end order. So he's charged person of recognizance, but order him to stay away from and have no contact with named witnesses and alleged victims. The defendant is now before this court on his petitions to vacate the stay away, no contact order. He argues that because he is a member of the media, the stay away order is vague, overbroad, does not apply to him without running afoul of the First Amendment. The section under which he is charged did not put him on fair notice what constitutes criminal behavior. So interesting. So the court is apparently going to address the lack of fair notice. So interesting. After 2 hearings and after careful review of the parties' numerous filings, including the parties' post-submission hearings, I largely disagree for the following reasons. Defendant's interest in the case. So he is a local blogger and activist. So apparently the court finds that he is a local blogger and activist. The court doesn't say he's an award-winning member of the media. Under Turtle Boy, follows Turtle Riders. He's taken a shine to a case pending in the court. In the Reed case, she faces murder charges for the 2022 killing, yada, yada. The Commonwealth alleges that Reed killed O'Keefe by hitting him with her motor vehicle before leaving the scene. Proctor is the lead investigator. Proctor is married to Elizabeth, who otherwise has no role in the Reed case. Witnesses in the Reed case include Matthew and Jennifer McCabe, who were with Reed and O'Keefe on the night O'Keefe died. Brian, Julie, Chris, and Colin Alpert, who own the property at that address, were with Reed and O'Keefe on the night O'Keefe was killed, and or were interviewed by investigators, and Julie Nagel, who was at the address the night O'Keefe died. To say defendant has taken a pro-defense position in the Reed case is to understate the level of his partisanship and advocacy. You're not reporting anymore, bro. See, yada, yada, which quotes defendant as writing or saying Karen Reed is a completely innocent woman, wrongly charged by corrupt cops who would see her rot in prison in order to cover up a murder of a fellow officer, and about the deceased's family. With the O'Keefes, enough of the fucking pity party for these fucking people. The only good part about John O'Keefe not being alive is he didn't have to be around useless maggots for a second more. Fuck you, fuck your high horse, burn in hell. That's just good reporting, folks. That's just good reporting. That did kind of happen. But, you know, in Aiden's defense, there's a lot of beef on Irish. He's a beefy boy. He's bigger. He's fatter. And weight does play into it. That's why they have weight classes in boxing and most martial arts. That happened too. Twice. So the second time, he fucking knew what he was getting into and he went anyway. What does that tell you? What does that tell you? What does that tell you, my boy? As these quotes suggest, defendant prides himself on not being a conventional journalist. According to the Boston Magazine piece, defendant claims that the beauty of Turtle Boy is that I could do things in an unconventional manner, unconventional, that other journalists are restricted from doing. I love being the center of attention and being theatrical and performing. That is what I was made to do. He's in the theatrical. He's a thespian. In pursuit of his performative journalism and personal brand, defendant has berated witnesses in the Reed case, badgered them, although they have indicated they do not wish to speak to him, and pressured them to change their testimony. There's a footnote here that is important. Journalists generally adhere to codes of ethics that constrain their behavior. See Code of Ethics, Society of Professional Journalists, available here, that states ethical journalism treats subjects and matters of the public as human beings, deserving of respect. Pursuit of the news is not a license for arrogance or undue intrusiveness. Journalists should respect the rights of people involved in the news and to observe the common standards of decency. Defendant does not appear to subscribe to those codes. Defendant has been able to increase his following substantially based on monthly page views and viewership with his confrontational stories, live videos, and inflammatory blog posts about the Reed case. Harassing conduct and telephone calls. The criminal complaints against defendant in the Slotin District Court arise out of defendant's actions reaching out to witnesses and their family members, organizing a caravan of vehicles to drive by the homes of witnesses or family members, and posting veiled threats, sarcastic and rhetorical questions, and other harassing information in the course of this, quote, reporting, end quote, on the Reed case. These actions are reflected in reports by Massachusetts State Police Detective Brian Tully, submitted in support of the Slotin County District, or the Slotin District Court, complaints and borne out by the video clip supplied by the Commonwealth after the November 1, 2023 hearing. Defendant contends that Detective Lieutenant Tully takes some of his statements out of context. Who's that other motherfucker? 13 Kings or something with all out of context. To the extent possible, I've tried to confirm the accuracy of the quotations in this decision by reviewing the actual video clips supplied by the Commonwealth. So I guess he took them in context. I describe only some of the actions by defendant set out in Detective Lieutenant Tully's reports. Defendant has posted a number of YouTube videos in which he issues veiled threats to various witnesses in the Reed case, or encourages his followers to take actions with respect to such witnesses. For example, after visiting witnesses' homes in Canton, defendant posted a video online, episode 594, in which he stated, "It must frustrate him to no end, because I know Brian Albert is watching this right now, to watch me just emasculate his family time after time, and there's nothing he can do about it." Hindsight. Apparently there was something you could do about it. There's just nothing you could do, and I'm just going to keep doing it. This is not my last trip to Canton. I will be back. And more I think people are getting, like a year or so ago, people don't want to cooperate with Karen Reed defense team. Because they're like, yeah, it's easier to keep my head down and, whatever, and keep a low profile. But now they're like, fuck it. We've made people realize they don't have nothing to be afraid of. In the same post, defendant states, quote, "You haven't seen the last of me. These people think that I'm fucking around like I'm Mr. Internet guy, like I'm going to sit here and I'm going to write blogs all day. No. I live an hour away. I've got a Lexus now. I'll be there in an hour. No problem. Get used to it." End quote. In another video, episode 598, defendant states, "I confronted this guy, Chris Albert, a couple weeks ago. This guy has his head on a swivel. Everywhere now, he's turned around like, where are they? Got bad news for you, Chris. I got really bad news for you. They're literally everywhere. You can't, you guys should just stop going out in public." That would be my recommendation. And it's only going to get worse from here. It's only going to, I did not direct this person to do this. I can't stop him. Oh, wait, I can't stop him. I can't stop him, he says. I fucking order them. They're my turtle riders, but now he's saying I can't stop them. Huh? That's fucking crazy. They're everywhere. They don't like you. No one likes you. Nobody likes you. You guys killed someone. You literally killed someone. Not you. You didn't do it. But you raised someone who did it. And, your big bro did it. I'm really low, sinking down in this chair. But you obviously know this and you're helping cover it up. But I guess you didn't kill anyone, so you got that going for you. So good job, Chris. You just raised a killer. Chris, I know where you guys were today. Y'all were in Agawam, weren't you? I got pictures of you in my cell phone. I got people sending me pictures. You guys were at some sort of Little League thing in Agawam. Alberts, McCabe's, all of you were there. So just know that there will be no life as normal is over. I thought you were just here for Kate Cities, WTT. Defendant traveled to Canton and went to a pizza restaurant owned by Chris Albert. Later, according to Detective Tully, on a video posted on YouTube, defendant encouraged his followers to order food from Chris Albert's restaurant but not pay for it. That's kind of harassing, isn't it? Amen, brother. Amen. Where did you finish your law school class? At McGeorge School of Law in Sacramento? Are you asking me when did I graduate? Well, I could probably work out a deal, titty for titty. And my cut is a copy of each. After the defendant posted this video, Chris Albert's video had a vast increase in the number of telephone orders not picked up or paid for. That's kind of harassing. Tully indicates the defendant made other trips to the same restaurant and held signs and confronted people in and around the restaurant. On a blog post, which contained a video of Chris Albert being confronted by one of the defendant's followers, the defendant bragged about how turtle riders were sending him pictures whenever or wherever witnesses were out in public, including on vacations. They're turtle riders now. They're turtle riders now. Before he couldn't control them. Now they're turtle riders. And he orders them. He warned witnesses, you can't leave the fucking country with turtle riders. We're going to find you. We are going to find you. they're going to find you. Your private life is over, officially over. So you need to get used to your new normal. This is your new normal. Tully also described the defendant saying on same post, I was so proud to see Turtle Riders unafraid, confronting evil like this in the flesh. Murderers and those who cover for them do not deserve to live a comfortable life while Karen Reed suffers and fights for the justice of John O'Keefe. In April 2023, defendant started writing blog posts about Trooper Proctor's wife, Elizabeth. On April 17, 2023, defendant posted on Twitter a statement alleging Colin Albert is responsible for O'Keefe's murder and that Colin and O'Keefe had a fist fight at 34 Fairview Road. Since then, defendant has authored a number of other posts about Colin, his alleged propensity for violence, and personal information, including where Colin will be attending college. Since then, Colin has been targeted harassment and intimidation on social media. Employees of the college Colin planned to attend received emails from people who copied defendant's allegations. Intimidation. According to Tully, in a video posted on May 9, 2023, defendant displayed Elizabeth Proctor's cell phone number and indicated both Trooper Proctor and his wife are lowlifes, bullies who terrorize people for years and deserve to lose their jobs over the Reed case. Defendant publicized the identity of Elizabeth's employer, which had no involvement in the Reed case, identified her position with that company, and posted the main telephone number for the company. Defendant encouraged his followers to leave a review on company's open Facebook page or Twitter account. When defendant learned Elizabeth's employer had taken down its social media accounts, he laughed and described it as a Turtle Boy effect. He took responsibility for it. The next day, defendant posted a live YouTube video during which he repeated Elizabeth's cell phone number and called the number and left a message containing the following. Hi, Elizabeth. This is Aiden Kearney calling you back from Turtle Boy. I noticed that your employer took down those social media pages within minutes of the blog I published about your recent behavior, and I just wanted to see is it awkward? Were you afraid to go in? Just tell me about your day and why, because that's like the part I don't understand is that you seem to be okay with calling other people's workplaces and interfering with their ability to make a living for themselves. But when it happens to you, maybe it's not as fun. Maybe it's not as fun. Do you like that? That's what I want to know. Did you like that? Because you've been doing that to a lot of other people. And do you think that's fair that it happened to you, dear? Do you regret it? Do you regret it? And that's what your scumbag husband up. And what's your scumbag husband up to right now? Are you going to visit him in prison? Do you think they'll have conjugal visits? Give me a call back when you get this, and we can chat some more. Bye, girl. On June 6th, defendant traveled to Billerica and confronted the McCabe's at a youth sporting event. Defendant later posted videos of the interaction online. Defendant said in a blog post about the incident that the McCabe's do not deserve to live a normal life and pretend that they weren't involved in murdering a Boston police officer. Defendant also bragged in a YouTube video that he gone to Jennifer's kids lacrosse game and made a scene there and got kicked out because I kept calling her a cop killer. Investigative journalism. On June 16, 2023, defendant broadcast a YouTube video which displayed records from Jennifer McCabe's phone from the day O'Keefe was killed with the names next to the phone numbers. Documents have been an attachment to an unredacted defense motion filed in the Reed case. Defendant called Michael Proctor's work cell phone, disclosed the phone number, and left voicemail, which was also broadcast on YouTube. In the broadcast voicemail, defendant asks questions of Trooper Proctor, describes personal information he knows about Trooper Proctor, and reiterates that everybody watching also has your phone number, which again is blank. And the defendant then repeats the cell phone number. Within the next 12 hours, Proctor received text messages, phone calls, and voicemails related to his involvement in the Reed case, with some calls urging Proctor's termination. He had to change his work phone number as a result. The court omits the number. I think the number is pretty low, but with all the other stuff, it adds up. Mr. Caruso. Around the same time, the defendant also called Julie Albert, Chris's wife, harassing her. He left her a voicemail message commenting on her appearance, asking questions about her interview by the police, and how long her family had known Trooper Proctor. The voicemail closes as follows. But what I'd really like to know is if you were in the Canton High School class of 94, how the hell did Jen win best looking? Were they using Dominion voting machines? Like, how does that happen? And how does that hurt your self-esteem to know you were in the same graduating class as Jennifer and she got the best looking. Like, does that hurt? Like, how do you cope with that? Do you need therapy? That is to hurt your feelings, right? Because that would just devastate me if I lost to Horseface. So give me a call back when you get this and we'll talk soon. Bye. On June 19th, 2023, a defendant called Chris's phone. When there was no answer, defendant left a voicemail calling Mr. Albert Chicken Parm Charlie and identified himself as award-winning journalist Aiden Kearney. That whole identifies himself as award-winning Kearney. Just fucking every time, man. Every time. Like, if you have to tell people you're smart, you're not smart. If you have to tell people you're good-looking, you're not good-looking. If you have to tell people you're an award-winning journalist, you're probably not an award-winning journalist. After asking questions about how long Mr. Albert's family has known Trooper Proctor, the defendant ends the voicemail with the following. So you guys both have amnesia that day that you needed to be formally introduced. Do you often need to be introduced to people that you have known for a long time? Do you live perpetually in Groundhog Day? I know this was right around Groundhog Day when this happened, so maybe it just kept replaying and you got to do it all over again the next day. I don't know. I'd like to learn more about this. So if you get back to me, that'd be great. And also, I'd like 2 blackened chicken parms, extra mozzarella, and we'll see you soon. All right, that sounds delicious. I'm hungry. I'm hungry. It's past lunchtime. Jesus Christ. I have donated so much of my time to this bullshit. On June 26th, defendant went to McCabe's home in Canton and videotaped the residence, including videotaping into the home through an open front door. Defendant has also published photographs of one or more of their children. Investigative journalism. One or more of their children. Photographs of McCabe's on vacation and a video of a sign on the lawn of Jennifer McCabe's sister in Canton. He went to her sister's house. In the latter video, the defendant states, "You're better off staying out of this. This sign, that got me. This sign fucking disgusts me. You worthless piles of shit killed John O'Keefe, and you have the balls to put these fucking signs in your yard. You have the balls. Why? Because we're fighting for an innocent woman's life. You killed John O'Keefe, you worthless piles of shit, and I'm going to find you, motherfucker. I'm going to find you. Just know that. You want to fucking dance? We can fucking dance. I don't know who you were before this. I thought you were Jennifer's lesbian sister or some shit. I didn't know shit about you. Now we all know about your son, Tommy." Now we all know about your son, Tommy. Like, what the fuck is wrong with you, bro? And Tommy's the lacrosse coach, I believe, at the Canton High School, right? Yeah. Whoa, we can talk about Tommy too. We can pay Tommy a visit too. We're gonna go get the whole fucking deal right now. All of it. Allie, she can get it too. They can all get it. We left the second generation out of this for a bit. That's over. Jesus, Aiden. What the fuck, dude? What the fuck? Like, really, bro? Like, what the fuck? What the fuck, dude? You may or may not be Aiden. Like, what the fuck? Like, why are you threatening their entire family over this? What the fuck is wrong with you, bro? Like you have some special knowledge about who did it? Like, you know more than anybody else? Like, you're fucking smarter than the prosecutor and the police and the judges and everybody else? What the fuck? On July 8th, defendant broadcast a live YouTube video during which he called Colin's cell phone, broadcast Colin's cell phone number, and calls Colin the fucker. When the call, you know what? I wish people called me the fucker. You know, that would imply that I was good at fucking. Obviously, none of my exes have ever called me the fucker. They've called me a fucker and a motherfucker, but not the fucker, because apparently I wasn't that good. When the call went to voicemail, the defendant left the following message. "Yo, Colin, it's Turtle Boy from them Advantage boys. Bang, 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 bang. What does that mean, Aiden? What does it mean when you leave bang, 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 bang on someone's voicemail? Followed by, yo, we'll fuck any of you dogs up. Yo, you challenge my boys, the Advantage boys, to a fight. Dog. What the fuck, dude? And we about that life, son. We about that life. And we from Sharon, son. Yo, y'all Canton bitches ain't shit, yo. Us Sharon bitches Advantage boys. Nobody be fucking with us and shit, dog. So, yo, call me back. What the fuck, dude? No, but seriously, it's Aiden Kearney from Turtle Boy Daily News. I just want to know, were you the one who killed John O'Keefe, or was that your Uncle Brian? Who hit him first? Who hit him in the back of the head with the thing? And are you worried that you're going to jail for the rest of your life and that you won't be able to play football at Bridgewater State next year? See subtle things. And I don't know if what's his name? Felipe is here. Hey, Felipe, I don't know if you're still here, but you know, it's creepy and fucking weird when you drop like personal details about people. Like you're implying that you could do shit. Just for the record, buddy. For the record. Love to have a conversation with you. Your dad kicked me out of your pizza shop, and I didn't get to eat his mediocre chicken parm. Well, if you didn't get to eat it, how do you know it's mediocre? So I just wanted to know if you could talk to me about that. Talk to you about getting kicked out of your dad's pizza shop, or about his mediocre chicken parm that you didn't eat, that you couldn't eat. No, I'm not gonna. I don't watch Aiden's content. I don't watch Aiden's content. I don't like Aiden's content. I just want to know if you could talk to me about that. Maybe you could tell, maybe you and I could go for a ride. We could find them Advantage boys. Bang, bang. Again, like, I don't know what the fuck that is, but that sounds awfully threatening. I don't know, so give me a call when you get this. Bye. After leaving this message, defendant spoke to his followers on the same video and reminded them that they had heard Colin's phone number and they could replay the video to get his phone number. Defendant organizes drive-by of homes. Drive-by. This is now a drive-by. It's not a rolling road rally. This is a fucking drive-by. Defendant organized and publicized a rolling road rally to bring his followers to homes of witnesses. Specifically, the court thinks that he did it specifically to bring his followers to the homes of witnesses and to the lead investigator in the Reed case. At about noon of July 22, defendant met a number of other vehicles at a Shaw's in Norwood. He live streamed the vehicle caravan, representing there were 100, 200 people in the caravan of vehicles. Video clips that the Commonwealth and defendant have submitted to the court after the November 1, 2023 hearing show a crowd of people on the street with defendant at various stops. The vehicles first drove to Brian's residence in Norwood. During the video, a defendant bragged about being able to locate the witnesses wherever they travel. That's not creepy at all. A second location was Proctor's home. The Proctors were not at home. Defendant stayed at that location for about 7 minutes. During that time, defendant used a megaphone to say that the Trooper Proctor had, quote, framed, end quote, Reed and stated personal information about Dr. Proctor, about Trooper Proctor's family. That's not creepy at all. While in front of the Proctor's home, members of the protest, which was organized and fomented by defendant, walked on Proctor's lawn and spit on his driveway, according to Tully. Again, he took responsibility for them. They are his turtle riders, and he gives them specific orders. Yeah, I like my dog way more than I like any of you. Take that as you will. The third location was at McCabe's home in Canton, where they live with their 4 children. Sweet. Taking it to people's house where they have their 4 kids. Nice. And the McCabe's are obviously public people, right? Because they happen to be witnesses, so now they're public people. So we need to blast them and their kids in their home. Defendant spent about 8 minutes in front of McCabe's home. On his video, defendant said that Jennifer is going to jail, participated in murder, manufactured evidence, and lied to investigators. Defendant took bullhorn so that he'd be heard by the McCabe's neighbors, saying, I just want all of Jen's neighbors to know, in case they don't already know, the people living right here at this address, there are cop killers. There are cop killers, folks. There are cop killers that live here. They are going to try to live like nothing happened. We're not going to let them do that because you do not get to kill police officers and fathers and get away with it. And if he had any fucking money, if he didn't live in his wife's house, he would probably be getting sued. Like with all of this shit, especially if he gets convicted, I would assume that it would be a pretty easy case for defamation. I would assume that. The Rolling Road rally went by Juliana's home in Canton. Juliana was at the home. She lives in that home with her parents and 2 siblings. Defendant stopped at Nagel's home or Juliana's home for about 10 minutes. At the location, defendant announced that Juliana lives at the residence and urged her to come out and tell the truth. That's not to have Juliana's neighbors pressure her. Tully quotes defendant as saying, you might as well tell the truth and let the world know what happened. Neighbors, maybe you guys can help us pressure them. Witness intimidation, help us pressure them into this. Well, so there's a lot of considerations on defamation, and one of the things is recover. How much you can recover? Does the dude have any fucking assets? And that's one of the things attorneys look at in determining whether or not to take a defamation case. And suing, like, I know that some people want them to sue regardless, but defamation cases are motherfucking hard to prove. That's number one. Number two is you got to collect. At the end of the day, you got to collect. And if the person doesn't have any fucking money, then attorneys are only going to do it on an hourly basis, and attorneys are expensive. Isn't that right, Kate? Isn't that right, Kate? Nothing that I'm doing here is for or against Aiden. You don't know what I know or what I'm doing or why. I assumed, and I still think he is, Turtle Boy's not stupid. He's not a stupid man. He's doing some really stupid shit, and I don't know if that's just because of hubris or whatever, misunderstanding of the laws, thinking he knows more than he does. I don't know why. I mean, I'll leave all of you to fill in the why. All of you love to be psychics and tell me why people do shit. He's not a stupid guy, but he's doing some really stupid shit. This is really stupid shit. I don't know why he fucking did it. I don't know why he's calling on people to help us pressure witnesses into doing shit. Like holy fuck. How goddamn dumb are you, though? Like, oh. Anything you say can and will be used against you. Don't go out there and just say, help us pressure witnesses into doing what we want and subverting justice. Help us pressure them. I clearly am intending to pressure them. I'm going to use bullhorn, telling my neighbors to help us pressure them. I'm missing the context, people. There's context under which this could not be advertising for people to help you intimidate witnesses. There's a context that's missing here, folks. It's like when the wife opens up the door and husband's like balls deep in the babysitter, and the wife goes, "Oh my God, you're cheating on me!" And he's like, "Honey, you're missing the context of this." Holy shit! You're missing the context. You're missing the context. The context is you're out in front of a witness's home, knowing that she's a witness, intending you set up a fucking rally to not only be in front of this witness's home, but to bring a whole bunch of motherfuckers here. You brought a bullhorn. You are giving a fucking speech. In that speech, in front of the witness's house, who you know is a fucking witness, you are saying, "Help us pressure this witness." One more fucking context. One more fucking context. Holy fuck. I'm glad I don't have neighbors who live very close. What more context, dump truck? Come on, dude. I'll wait for you. I will fucking wait for you. Pound it out. Pound it out. You know what? You know what, dump truck, buddy? You know what? Fucking hold on a second. Hold on a second. Come on up. Come on up. Come on up, you fucking dipshit. Come on up. Come on up, dump truck. Give me the fucking context. Give me the fucking context. I hate to break this to you, but according to Coded, I get a little mean when I've been drinking the bourbon. So this must, ipso facto, be bourbon. Potentially, yeah, potentially. Well, I don't know if a change of venue would help. The stuff that he was talking about, like getting the billboards and shit. That might taint the jury pool, but I don't know. I mean, that'd be something that somebody would have to bring a motion for. At least I'm assuming that. I don't practice law in Massachusetts, and I don't know all of their criminal procedures and stuff. So, I mean, I don't know. Come on up, bro. You're just restating that this is missing context. You're just restating it. This adds nothing further. Come on up. Mr. Caruso. Mr. Caruso. Mom, I'm screaming. No. I'm going to clean this room. Mom. Come on, dump truck. You dipshit. Let's go. Let's go. Let's go. Come on, dumpy boy. Give us that context. Show me the context. So there's no fucking missing context here. There's zero missing context. He organized a rally specifically to go to these various witnesses' homes. He brought a bullhorn. He brought a crowd. He went to one of the homes. At that home that he knew was hers, he used his bullhorn to address not only the crowd, but the neighbors, and called upon them to help us pressure her. Help us pressure her. Like, what more do you need, bro? There is no other context. There's no other context. You have no clue. I'm smarter than you, and you have no clue, Burb. I can't explain it. I just know. I feel it. I just know. Just like that other fucking dipshit at the beginning who, regardless of the truth of it, just knows that Turtle Boy's a liar. Like, it doesn't even need proof, just knows, right? You're just like that. Yeah. All right. So I guess we'll move on. We're moving on. He continues. She knows what happened, and she is actively involved in the cover-up. He's saying to her fucking neighbors with a bullhorn. She should not be able to walk around town like none of this happened while an innocent woman named Karen Reed suffers the consequences of her silence and her complicity. While traveling to the next stop, Turtle Boy, that would be literally the dumbest thing that you could do. Like, it is your fucking mouth. It is your fucking mouth that got you in this situation. And to protect you, Aiden, to protect you from your own fucking stupidity, I'm not going to bring you up here. Because anything you say can and will be used against you. So, it's not happening here. You were an idiot for going up on those other attorneys' panels or whatever, and I'm not going to let you do it. And it's not that I think you'll own me or anything. I would not let anybody up here. Back when I was doing interviews with people a long time ago, I would not let people get up and run their fucking mouth about cases that were ongoing. Like, he's looking at a lot of fucking time. He's looking at a lot of time. I'm not going to let him do it. And you can call me simp all you want. So, anyway, to continue, while traveling to the next stop, defendant broadcast at the stop at Miss Nagel's house was a good one because they're home. Well, so I assume that he was dump truck, and I assume he would not come up. But if he wants, like, I can't do it. I just can't. I cannot do it. I have been the attorney for defendants before, and the last fucking thing, and even in non-criminal matters, like, the last thing you want is for someone to get up and talk about ongoing litigation. Oh, well, okay. Yeah. Well, yeah. So there you go. Other contact. So the court is not done yet beating him down. In and before late September 2023, defendant obtained information about motor vehicle registrations from the Criminal Justice Information Service database from Janelle Webb, a civilian dispatcher with the Avon Police Department. Defendant knew or should have known that it was illegal to obtain or have Ms. Webb obtain such information. On September 25th, defendant tweeted a photograph and a message depicting vehicles parked at the Proctor's home, including information about the vehicle registrations that he improperly obtained from Webb. On September 24th, and so another thing about that is that the by doing that, by posting that, he is basically saying that he has all this information about him. It's, again, a veiled threat, an implied threat. Felipe, the last time that you peer pressured me into anything, oh wait, that never happened. So on September 24th, the defendant broadcast a live YouTube video when talking about an interaction he had with Colin's aunt. This motherfucker had an interaction with Colin's aunt. Like, how far out in this fucking family tree did you go, Aiden? How fucking far out in the family tree did you go? This is Colin's third cousin. What the fuck, dude? His aunt. The defendant said, I'm trying to put her like godson nephew in jail and, kind of like destroy their life. I don't think you understand. You won't. This isn't looking good for you, bro. You need to stop. You need to stop talking. Like, you literally need to stop fucking talking, bro. You literally need to stop fucking talking. You shut your fucking mouth. I mean, talk about the Reed case, fine, great, but don't talk about your case. Like, that is the last thing you want to do. Like, every attorney, ask your attorney. Hey, Mr. Attorney, what the fuck is his name? Ask Mr. What the fuck is his name? Ask your attorney, Mr. Bradle, if your attorney wants you to be out there talking about your case. Ask him. Ask him if he wants that. Ask him if it'll make it easier or harder for him to defend you. Ask him. I know he does. And he's not. Like, no, you can't. Sorry, dude. You can't. You've been dumb and wrong this entire time. You've dug yourself into a deep fucking hole. And I'm like, hey, give me the spade back and stop digging. And they're like, no, I got this. Because your attorney who's making money off telling you should fight this and this and that and the other thing, this is free advice. No, shut the fuck up. Free advice. On October 2nd, defendant posted a video on YouTube. During that video, defendant stated that you, Chris, don't have the right to live peacefully, dude. That's not a thing. Again, I guess I'm missing context there. Procedural history. On October 11th, defendant was charged with and arraigned on 9 criminal complaints, each charging one or more of the crimes of witness intimidation, violation of this, unlawful picketing in order to influence a witness, and conspiracy to commit witness intimidation in violation of that. The different criminal complaints involve different alleged victims. No, I'm not. No, sir. No, I didn't say I know more than your attorney. I'm saying that your attorney has a financial interest in you making this money. The more motions he gets to do, the more things that he gets to do, the more money, generally speaking, he's going to get to bill out of you. I've heard, and I don't know, that they took you on a flat fee, or $100,000. I don't know what all that covers, but maybe to negotiate that, he let you do all sorts of dumb shit. But still. I'm not saying he definitely knows. He definitely knows more about Massachusetts law than I do, 100%. But I can see it blowing. I can see it blowing in the wind from what you were doing, just from a cursory examination. Well, I didn't say that. I absolutely didn't say that. And I said he has a monetary incentive to have the pot stirred as much as possible to be able to bill you as much as possible. There are two kinds of attorneys out there. There really are two kinds of attorneys out there. I am the kind of attorney who I try my best not to charge my clients out the gate, like as much as possible. My thought process is that if I do right by my clients, I'll get more referrals for them in the long run. I work with an attorney who his process is to go gung-ho, guns blazing, file all the motions, do all the things, regardless of whether or not it'll win. And he disguises under, I'm going to fight for my client. We're fighting for our client, John. We're fighting for our client. And while I do fight for my clients, I try to take calculated risks. And I try to advise my clients of things that will potentially save them money, embarrassment, et cetera, in the long run. Yeah. I don't know if that's true or not. And he's not here to tell me about it. So why don't you have your attorney come up and explain to me the context? Because your attorney's words can't be used against you, and it's a flat fee, so you shouldn't have an issue with it, right? So have your attorney come up. It's a joke. It's all a joke. You obviously haven't listened. I know. I haven't listened to the audio. I normally don't. I don't watch your shit. Number one, and number two, I don't have to listen to the audio because the court has made findings, and I can look at what the court's findings are, and I can be like, oh, hey, this is what the court found. So regardless of what you think the truth is or what you think the audio is, the court allegedly watched the videos, watched the surrounding context. At least that's what the court says, and the court made determinations of fact about what you said, what you did. And that's what's important. That's what's important. That's the context. That's the context. Well, maybe you should. You might learn something. So that's a lot of stuff right there. Also on October 11th, Judge O'Malley released defendant on personal recognizance and entered an order on all 9 dockets requiring defendants stay away from and have no contact with the named witnesses or alleged victims. In his order of pretrial conditions of release, Judge O'Malley placed an X in the box next to have no contact, direct or indirect with, circled direct or indirect, and wrote in stay away plus no contact from each named witness via any mechanism. He also placed an X in the box next to stay blank away from, wrote in Julie Albert, Michael Proctor, blah, blah, blah. Judge O'Malley did not specify a particular distance defendant had to maintain from the particular witness in order to satisfy the stay away obligation. Well, that's a problem. That's a problem. Judge O'Malley did not put that's a problem. Defendant now appeals the stay away no contact order. He argues that all of his actions and statements were done as acts of indisputable journalism, and the district court's order will have a pronounced chilling effect on his ability to continue to cover the story of the Reed case and will constitute a prior restraint on his speech. He also argues that the stay away / no contact order is vague and essentially gives these 8 individuals veto power over his reporting by allowing them to simply show up at any venue, any public place, any courthouse relevant to his reporting, and flush him out, evicting him at will under the risk of 90 days incarceration. In subsequent filings, defendant argues that the state statutes in question are vague as they apply to him. Discussion. Number 1, authority to review stay away no contact order. We have the authority. This court has statutory authority to issue the stay away no contact order under Massachusetts law in considering bail. If a judge of the district court determines it to be necessary, the judge may order the defendant to abide by specified restrictions on personal associations or conduct, including but not limited to avoiding all contact with an alleged victim of the crime and any potential witnesses who may testify concerning the offense as a condition of release, in contrast to the conditions imposed under blah, 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 which require the defendant's consent. This expressly authorizes the judicial officer setting bail to include a stay away no contact order, even over defendant's objection. Okay, so that is something I did not know, or I thought it was one of those things where the court said either you can accept bail under these conditions or you can fuck off. You're not coming up, Turtle Boy. I already told you no. You should learn. You should learn, Turtle Boy. So I thought it was one of those, but apparently this is one where the court can just plain order it. So that's interesting. That's something I did not know. In contrast to conditions imposed under that, which require defendant's consent and expressly authorize bail to include a stay away order, even over defendant's objection. The parties agree the Superior Court has power to review the conditions set by the district court. Yada, yada. Blah, blah, blah. Rather than challenging the court's legal authority to issue a stay away no contact order, the defendant challenges the factual basis for the charges against him, particularly charges of witness intimidation and unlawful picketing. Defendant does not appear to challenge the factual basis for the charge he conspired with Webb to procure CJIS information to which he is not legally entitled. Tully's reports, which provide excerpts from recordings later submitted to this court on a thumb drive, demonstrate more than sufficient evidence to support the criminal complaints. That's what a court found. Oopsie doodle. Massachusetts law makes it a crime to threaten physical, emotional, or economic injury or to harass a witness or a witness's family in reckless disregard of the fact that it may interfere with the criminal case. Our law also bars retaliation against a witness for participating in a criminal case. The relevant Our law also bars retaliation against a witness for participating in a criminal case. Relevant provision states whoever willfully blah, 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 blah. For purposes of the statute, the term harass is defined as any act directed at a specific person or group of persons that seriously alarms or annoys such person or group of persons that would cause a reasonable person or group of persons to suffer substantial emotional distress. For a defendant in violation of 13B subsection B is punishable by up to 20 years in state prison or 2.5 years in a house of correction because the proceeding in which the misconduct is directed at. The Reed case involves the investigation or prosecution of a crime punishable by life in prison. 20 years in a state prison. If his attorney wants to come up, and if he's here, I'll bring him up. I don't have a problem with that. Because, see, the distinction is that anything Aiden says can and will be used against him. He's dumb. He thinks it won't. He thinks he's smarter than that, but it can and will be used against him. Anything his attorney says that it can't. Anything his attorney says cannot be used against Aiden. Your attorney cannot stop you from doing it. Your attorney cannot stop you from doing it. But I seriously doubt he wants you to do it. You know, another benefit of being innocent is that you are less likely to get convicted. Less likely. That doesn't mean you won't be convicted. You could be convicted. Even if you're innocent. There's lots of innocent people who've been convicted. You keep resorting to the same lines. Same lines. He told me he wants to. Oh, I believe you, Aiden. I believe you. I totally believe you. There have been lots of innocent people who've been convicted. All right, where are we at? Detective Tully's reports demonstrate a concerted effort, a repeated pattern of conduct designed by defendant to cause or threaten economic or emotional injury to witnesses or family members of witnesses, and to harass those witnesses and to get them to change their testimony. Defendant's actions in soliciting his followers to contact Elizabeth Proctor's employer to order food from Chris Albert's restaurant and not pick any of it up or pay for it, and to contact the college, call and attend or plan to attend, were all designed to and did inflict economic or emotional injury. So that must be the economic injury right there. So that's one of the portions. I didn't know that he was doing that before I started reading the other things, but apparently that's what he was trying to do. I guess I just need more context. What due diligence? Hold on a second. What due diligence? Jennifer? What due diligence? What statute, rule, whatever? What due diligence? You're not a defendant. You want to come up and tell me what due diligence that I had to do. You heard these words before, due diligence, and you think you're going to apply them to me. Most hosts know content before doing a show. So that's what most hosts do. I don't. What's your point? A court found you did. A court found that you did. I mean, that's not necessarily binding on the jury, but a court found you did. Now what? You know what every defendant says in prison? I'm innocent. Go to prison. Just pick a prison. Pick any prison. Go in there. Pick a random person. Be like, did you do it? 99 times out of 100. No, man. I'm innocent. So the court found that he either called the restaurant and had him order stuff and not pick it up or pay for it, or he encouraged his followers to do it and to contact the college that Colin attended or planned to attend were all designed to and did inflict economic or emotional injury. But you know what? Just like Smarty fucking Pants. Where'd you go? Where'd you go, Turtle Boy? Was it? Where was it? Hold on. Was it this one? Where was it? I read about it. It was somewhere in here. It was somewhere in here. Where was it? So there was apparently a video posted on YouTube where you encouraged people to order but not pay for it. According to Defense Tully on a video posted to YouTube. So maybe. I guess we'll have to see, right? If it doesn't, yeah, what's the video? I don't fucking know. But yeah, you know what? They'll have to prove it, won't they? But that's one thing. That's just Chris Albert's. That's just Chris Albert's restaurant. You're not challenging the other stuff. You're not challenging the other stuff. And I don't even know where he got this. I didn't see that in any of these pleadings about the pizza place. So I don't know where that came from. I don't get to have all the documents, unfortunately, and I haven't been given all of the statements. Well, no. So I don't have all the documents, and I don't have all the statements. So I don't know. I don't know where they got it from. But a court found it to be persuasive enough. A court found it to be persuasive enough that a court found that happened. And you really should stop talking, bro. Cops never lie, right, Murph? Well, they do lie, but there's a difference. As I've explained it before to the simpletons out there, who I thought you weren't, but I guess I'll explain it to you too. There's a difference between a cop on the street who is more than willing to lie to you to get you to do what he wants, and a cop under oath. There's a difference. Cops are much less likely to lie under oath. Can they lie? Sure. But does that mean in this case he's lying? Why would he lie over this one? There's all this other evidence against you, with all this other evidence with citations to specific videos, right? There's all this other evidence. But the one thing you're fucking hanging your hat on is there's no citation to the thing about the pizza shop. Let's remove the pizza shop from the equation. So what? Everything else all of a sudden goes away too? No, I don't think so. I don't think so, bro. Because you got problems, dude. It's not one thing. You pull one straw out, and you still got a pile full of hay. So this one also, he quotes, Tully quoted the defendant as saying, so did that not happen? Did that not happen, Aiden? Did you not say help us pressure? Well, so I haven't watched any of the quote evidence, no, and I'm not going to, because I have the finding of a court. Why am I going to look silly? Why am I going to look silly? Explain it. Why am I going to look silly? Champ. See, you're arguing facts, and I'm looking at the law. And the number one thing that a lawyer has to do is accept the court's finding of what the facts are, or the trier of fact. It's very hard to overturn a trier of a fact's decision. No, I'm not going to let you on. In fact, you know what? Honestly, I really shouldn't be allowing you to. I should be highlighting your posts here, because that's encouraging you, and you might say stupid shit. So, good day, sir. All right, so where are we at? We were over here. So, other conduct. Defendant obtained the CJIS information on live YouTube video. No citation. Must all be fake. All fake. On October 11th, defendant was charged with and arraigned on 9 criminal violations. Yada, yada. Okay, we did that. Already do the stay away order. Makes a crime. Yada, yada. Tully's reports demonstrate a concerted effort and repeated pattern of conduct designed by defendant to cause or threaten economic or emotional injury to witnesses or family members of witnesses, and to harass those witnesses and to get them to change their testimony. Defendant's actions in soliciting his followers to contact Elizabeth Proctor's employer or order food from Christopher Albert's restaurant, not pick it up, yada, yada. We're all designed to and did inflict the numerous calls, voicemails, and the like reflect a systematic pattern of harassment designed to intimidate witnesses in the Reed case. Citing O'Brien versus Borowski, defendant argues that the witness intimidation statute should not apply because he engaged in protected speech under the First Amendment. O'Brien does not go nearly so far. The First Amendment does not authorize journalists to commit crimes. In O'Brien, the court considered a petition for relief from a stay-away order under a civil anti-harassment statute. The court held that the definition of harassment in that statute excludes constitutionally protected speech, and that the phrase intent to cause fear in the definition of harassment is limited to fear of physical harm or physical damage to property. Assuming, without deciding, the same limits apply to the witness intimidation statute, O'Brien still does not aid the defendant's argument. The charges against defendant do not stem from his speech alone, but also his conduct, which is not protected by the First Amendment. Moreover, speech such as, I'm going to find you, you want to fucking dance, and we'll fuck any of you dogs up, and defendant's speech designed to exhort his followers into engaging in threatening or harassing conduct are true threats that are not protected by the First Amendment. Nor can this type of speech and conduct fairly be considered journalism. In many of these examples, defendant is not reporting anything except for his own actions. Take, for example, the action of publicizing a witness's cell phone number and then broadcasting the sarcastic berating messages that defendant left on the witness's voicemail. Such a broadcast accomplishes only two things. One, it induces defendant's followers to call the cellular number to harass the witness, as some of the witnesses experienced. And two, it entertains defendant's audience with defendant's audacity and confrontational style. Defendant created theater, and an abusive theater at that, at the expense of the witnesses and the lead investigator in the Reed case and others related to them. True threats are words that are intended to place target and threat of the threat in fear, whether that threat is veiled or explicit. Defendant supplies no authority for his argument that the witness intimidation statute does not apply to journalists. That was a problem. Defendant is also charged in 594. Well, let's look at 594. I don't know what that is. Is that the dog? Is that the dog one? Is 594 the dog one? Where you go bang, 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 dog? Is that the one? Bang, 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 dog? Is that what 594 is? The first quote on the charging docs? Well, this is the only charging doc I have. So in a video posted shortly after Carney visited the homes of witnesses, he says, this is not my last trip to Canton. I will be back. I'll be back. Get used to this. People think I'm fucking around. You haven't seen the last of me. Get used to it. Get used to it. You see, smarty boy, it was proximate in time to visits to the home of the witnesses. That's a problem. And who were you talking to? We're on page 15. Because I think the court goes over that. I think the court went over that one. I thought the court might have gone over it. $594. Oh, look, returns to Canton. What's going on in Canton? What's going on in Canton? And you got kicked out of D&E Pizza. What's D&E Pizza? Huh? What's that? What's that in relation to, huh? Who's Chicken Parm? Who's Chicken Pam Charlie? Who's Chicken Pam Charlie? You fucking idiot. Go to the timestamp? No. How about no? How about you set it proximally in time? How about no? How about fuck you? How about that? How about that? And where were we? Where were we?
I didn't say it specifically about them. I just said it generally speaking on the same video where I'm going to Canton to intimidate witnesses, and I'm talking about Chicken Farm Charlie, and I'm assuming that the public official was probably that alderman guy, but I didn't say it specifically about them. I mean, it's just people can generally.
Oops, sorry, I meant to click that. I don't know. I have no idea. I honestly don't know. So I'm very sorry. I don't know. Couldn't even fathom a guess. I mean, number one, it would depend on how many he got convicted of. I'm assuming that on felonies there would be a jury for the sentencing who would do the sentencing. So I don't know about that. I don't know. I couldn't even begin. There's some. Is it possible he would do straight? He'd do straight time or straight probation? It's possible. I don't know. Where were we? I really do want to wrap this up. I really do want to wrap this up. Okay. Defendant is also charged for having picketed or paraded near witnesses' homes with the intent of influencing witnesses. There you go. According to Tully's report, defendant organized and orchestrated a rolling road rally to go to the residences of the witnesses. During the rally, which involved a caravan of vehicles and by defendant's estimate at least 100 people, defendant used a bullhorn to accuse Proctor of framing Reed and announced personal information about Trooper Proctor's family to inform the McCabe's neighbors that they were, quote, cop killers, end quote, and to recruit them not to let the McCabe's live like nothing happened, and to pressure Juliana's neighbors to get her to tell the truth about the cover-up. Such actions demonstrate an intent to influence and pressure the witnesses to alter the testimony about the Reed case. Given the existence of probable cause to believe the defendant committed at least some of the offenses with which he is charged, the district court had the authority to impose a stay-away order. Constitutional guarantees of free speech and free press. Lawful news gathering and news reporting is protected under the First Amendment of the United States Constitution. It is also protected by the Massachusetts Declaration of Rights. Constitutional guarantees of free speech and free press, however, do not protect advocacy that is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Brandenburg versus Ohio. Journalist actions are also circumscribed by the criminal law, at least to the extent the applicable criminal statutes, like those at issue in this case, are not solely directed at the free flow of information. See, they're not solely directed at the free flow of information. The freedom to gather information guaranteed by the First Amendment is the freedom to gather information subject to the general and incidental burdens that arise from good faith enforcement of otherwise valid criminal and civil laws that are not themselves solely directed at curtailing the free flow of information. That's from Reporters Committee for Freedom of Press versus American Telephone and Telephone Company from the D.C. Circuit. In addition, courts have an obligation to protect the integrity of the judicial process and may, quote, take such steps by rule and regulation that will protect its processes from prejudicial outside influence. Shepard versus Maxwell, see Seattle Times versus Reinhardt. Although litigants do not surrender their First Amendment rights at the courthouse door, these rights may be subordinated by other interests that arise in the setting. For instance, on several occasions, this court has proved restriction on the communications of trial participants where necessary to ensure a fair trial for a criminal defendant. In the context of a case, the court often finds it is necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. And again, in Estes, the right to a fair trial is the most fundamental of all freedoms. The most fundamental of all freedoms. Notwithstanding defendant's unusual tactics and inflammatory rhetoric, I assume for purposes of this decision, the defendant is a member of the press who, among other things, is covering a pending murder case. He's not, you can't reason with him, bro. You can't reason with him. He's smarter than you are, Paul. You might be an attorney, but you're not smarter than Aiden or Aiden's attorney. He claims that because he is a member of the press, it is a violation of his First Amendment rights in Article 16 of the Massachusetts Declaration of Rights to require him to stay away and have no contact with witnesses. Journalism generally involves eliciting information from sources who may be witnesses in a case, not attempting to have the witnesses change their testimony or inciting others to pressure witnesses to change their testimony. Defendant has no license in the name of journalism to intimidate or harass witnesses and jeopardize the integrity of judicial proceedings. For another citizen, such actions would not be tolerated. And the press has no greater right to do something like that than a citizen would. Notwithstanding the fundamental importance of news gathering and reporting, the First Amendment does not supersede the proper administration of justice and the court's obligation to ensure a fair trial, including protecting witnesses from intimidation. See Commonwealth versus McCreary. Purpose of the witness intimidation statute is to protect witnesses from being bullied or harried so they do not become reluctant to testify or to give truthful evidence in investigatory or judicial proceedings, and to prevent interference with the administration of justice. The right to a fair trial is just as important to the functioning of democracy as the First Amendment, or if you believe Estes versus Texas, it is the most fundamental of all freedoms and must be maintained at all costs. Due process right to fair notice of a crime. The defendant argues that the witness intimidation and anti-picketing statutes are vague when they are applied to him as a journalist. A basic tenet of due process requires that the criminal statute must be sufficiently clear to give notice of the prohibited conduct. A statute violates due process and is void for vagueness when individuals of normal intelligence must guess at the statute's meaning and may differ as to its application, thus denying them fair notice of the prescribed conduct. The underlying principle is that no man shall be held criminally responsible for conduct which he could not reasonably understand to be prescribed. See, that was the no man. That one. That is. This is the much more precise one. Got to be a person of normal intelligence. Penal statutes must define the criminal offense with sufficient definitiveness that ordinary people can understand what conduct is prohibited. Defendant asserts that the say-away no contact order should be stricken because these do not put him on fair notice that his conduct, which he describes as normal journalistic tactics, was criminal. I'm not persuaded by this argument. Fancy that. Neither am I. The words of the statute are commonly accepted and understood, and the term harass is sufficiently defined under GL 268, Section 13B, to put an individual on notice of the prescribed conduct. See McGee, 472, Massive 414. The language in the statute will be constitutionally adequate if it conveys a sufficiently definite warning as to the prescribed conduct when measured by common understanding and practice. The dearth of cases charging journalists with such crimes does not compel a conclusion that the statute is vague, particularly where defendant's tactics, as previously described, cannot properly be classified as typical behavior for a journalist. I am not making a definitive determination of the facts. The court has made a determination of the facts sufficient for this particular hearing. Now, I'm assuming they will be ultimately decided by the ultimate finder of fact, which presumptively in a felony case will be a jury. Now, Turtle Boy can always waive a jury trial and go with a bench trial, but he's entitled to a jury trial. And so I'm going to assume that at the end of the day, a jury will look at all the evidence, not just hearsay, which in a motion hearing is going to be allowable. Generally speaking, on a motion hearing, you could submit affidavits and things like that. In fact, this is essentially the same thing that Tully did. And Turtle Boy has an issue with the court believing Tully's. The problem is that Turtle Boy doesn't actually contradict. He doesn't actually go to the merits. He doesn't actually state in here anywhere that the allegations in the charging documents are untrue. He doesn't actually address the charging documents and say, oh, the charging document says X. If you go to this timestamp in this video, it actually shows Y. He didn't do it. He had a fucking opportunity. He didn't do it. But he wants to come onto my fucking channel and wants me to watch all of his fucking videos like I'm some sort of a fucking chump, but whatever. But yeah, it's the court can proceed on affidavits, generally speaking, on motion practice. The court had the affidavit of Tully, which was on point, and the court had the affidavit of Turtle Boy, which was not. Now, my assumption of why, and I don't often go into why, but my assumption of why is because Turtle Boy didn't have a fucking direct rebuttal. He didn't have anything fucking that directly said, your understanding of this is wrong. Tully says X and it's Y. He didn't have that. If he had that, if he had clear video evidence that showed that Tully's statement of what Turtle Boy said was wrong, why wouldn't he have shown it? I would have shown it. You got the fucking genius boy here. Why didn't you show it? Why didn't you show that the charging document was wrong? Why didn't you show it? I mean, you fucking had all these links, right? Look at all these links. Look at all these links. You fucking link to fucking Twitter. You link to Twitter. Link to YouTube. Could have done it. Could have fucking done it. Could have fucking look at all those links. Why didn't you do it? Why didn't you do it? Dumb shit. Conditions of release. There is evidence here that the defendant's statements and actions may intimidate witnesses involved in the Reed case and threaten the integrity of the proceedings in that case. Because I can. Never. There's evidence here that defense statements and actions may intimidate witnesses involved in the Reed case and threaten the integrity of the proceedings in that case. The language in the first paragraph of 276, Section 58, permitting a judge to institute a stay away, no contact order as a condition of release, clearly contemplates that limits may be placed on defendant's contact with the alleged victim as well as other witnesses, presumably for the purpose of preserving the integrity of the judicial process. The general stay away, no contact order is justified to protect the witnesses in the judicial process. In certain respects, however, the district court's order is ambiguous. First, by not including a distance in connection with the stay order, the district court did not provide the defendant with sufficient information that he could conform to his conduct to the court's order. I will amend the conditions, require the defendant to stay at least 100 feet away from any of the witnesses. Perfect. Perfect. Problem solved. Case closed. Second, it does not reflect consideration of defendant's interest in reporting the Reed case and whether or not there are less restrictive alternatives to allow defendant access to court proceedings attended by the alleged victims or witnesses in the Stoughton District Court matters. Here, a defendant has journalistic interest in reporting on the Reed case, which should be able to be accommodated by the court officers in the controlled environment of the courthouse. In the mine run of domestic violence cases in which one party to the case is ordered to stay a specified distance from the other party, both parties are permitted to attend their common court proceedings, even though it will bring them in closer proximity than a specified and stay order. This case is no different. Provided the defendant complies with the rules of the court, the defendant will be permitted to attend proceedings in the Reed case, even if victims or witnesses in the Stoughton matters are in attendance. I thought the court's order already said that he could attend court proceedings. Did these guys allege it? So according to the prosecution, the court specifically noted that the defendant was not prohibited from attending court sessions if the witnesses were present. Apparently, that was not on the actual order, so the court is now placing it on the order. So that's good. So the petition for review of the stay away no contact order is denied. As to the contact order is denied as a stay away order, except that it is amended. All right. Well, there you go. There you go.
I love how I proved that. I proved it.
You proved it the wrong place, wrong time. If you did prove it, because you didn't put it in here. You didn't put it in here. You should have put it in here, you dumb shit. Should have put it in here. And then the court might have made a finding. The court could have looked at theirs and looked at yours and said, hey, I believe Turtle Boy. But the court didn't do that. So day late, dollar short. Get the fuck out of here. Thanks for watching. Have a great day.